Quorum call.
Madam Speaker.
Has everyone recorded their presence? If so, the clerk will take the call. There being 128 members present, the House is now in session. The clerk will read the journal from the previous day.
Annapolis, Maryland, March 20th, 2021.
Recognizing Majority Leader.
Thank you, Madam Speaker. Move so much be considered the reading of the journal from the previous day.
So ordered. Petitions, memorials, and other papers. Quorum call.
Madam Speaker.
Clerk will take the call. There being 133 members present, House is still in session. Calendar of third reading, Senate bills number 37. Clerk will read the first bill.
Senate Bill 144, Electric Vehicle Recharging Equipment for Multifamily Units Act.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 106 votes in the affirmative, Senate Bill 144, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 156, Public Safety, Law Enforcement, Veterinary Care of Retired Law Enforcement Canines Act.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, Senate Bill 156, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 581, Action for Change of Name, Waiver of Publication Requirement.
Is on third reading and final passage. Is there any debate? If not, the clerk will take the call.
Madam Speaker.
Has everyone recorded the vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 125 votes in the affirmative, Senate Bill 581, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 623, Criminal Law, Crimes Involving Computers.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 135 votes in the affirmative, Senate Bill 623, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 752, Baltimore City Police Officers, Promotional Appointments.
Is on third reading and final passage. Is there any debate? Recognizing Minority Whip.
Thank you, Madam Speaker. Oh, sorry, I should have given you a heads up. Yes, I have a question.
Committee Chair.
Good morning. Can you tell us what this bill does, please?
The bill alters provisions relating to the number of applicants included on an eligible list for the Commissioner of the Baltimore Police Department. to make promotional appointments. So it gives, it expands the list of people who are eligible for promotion to 25% of the top of the people who are on the list who sought promotion.
So it's reducing standards or increasing standards, or how does, give me a little more practical information if you don't mind.
So right now there's a rule of 5, that the top 5 people who take the test are the only people who the commissioner can look at. What this would say is, okay, we're going to look beyond that. We're going to look at the top 25%, because it's possible that the top 5 are just really good at taking a standardized test, and the people down the list could actually have great experience in community policing or in other aspects of police work. And so we want to look at them and measure that as not just how they do on a test, but how they do at actual policing.
And is there, I'm assuming, additional follow-up on that? There's, evaluations, periodic evaluations to make sure that this change in policy is promoting the very best police officers. That, we're having quite a bit of discussion about police reform and making sure we have the very best in law enforcement.
That certainly is what the commissioner of the police department has been doing as part of our larger work related to the consent decree. We have a whole new training scheme in the Baltimore Police Department that is improving how police officers are trained, improving their performance in the field. And with that, and with changes like this, having a more holistic view of the people who are seeking promotion is important, so that we can have the best officers in leadership roles in the department.
So can you tell us how many officers are down right now? Is this going to help get more officers on the force?
The officers that we're down at this point, I know that we're down a couple hundred officers in the Baltimore Police Department.
Okay, so this could probably not help with
Deals with
that, because
promotions.
this is just promotion of
Yeah.
senior officers within the ranks, currently within the ranks.
This deals with promotion of officers who are already there. It doesn't necessarily deal with bringing more people in.
Okay. Thank you for that explanation.
Madam Speaker.
Recognizing the gentleman from Western Maryland.
Thank you. Just very briefly, my friend from Baltimore City. Is this the only police department, outside of the Maryland State Police, is this the only local police department in the state that the state legislature has to get involved in promotional standards and personnel practices and past state? It just seems odd to me that we're here debating bills about how the city of Baltimore, that the vast majority of us do not represent, how they go through a promotional or personnel practice for their own police department. Is that unique just to them in our state?
For now.
Right, and that was my question. So we passed some legislation, I think, this House at least passed some legislation that would disentangle the Baltimore City Police Department rules and regulations from state oversight, from sort of the micromanaging that this bill implies. If that bill passes and is signed and becomes law, we necessarily won't be involved in these types of decisions
I
anymore.
don't believe that we would be involved in these kind of decisions regarding the promotions list for the Baltimore Police Department, correct?
Okay, thank you.
Recognizing the gentleman from Queen Anne's in the Annex.
Thank you, Madam Speaker. Would floor leader rise for a question, please?
Good morning.
Good morning, sir. How are you?
I'm swell.
I'm in a phone booth right now, and I'm not going to take my tie off, so everybody should feel safe. Just a quick question for you on this. This says something about a complaint. Now, is this meaning that I can walk in and complain about an officer and that will hurt him in his promotional standing, or does it have to be a verified complaint? And
This is about the promotions process? One moment. It does, the bill also authorizes the commissioner to remove an eligible appointee from the list if, between the time the applicant applied for the promotion and the time in which the applicant is to be selected for the promotion, a misconduct complaint for which the punishment could be termination, if found guilty, has been sustained by the Civilian Review Board of Baltimore City or the Disciplinary Review Committee against the applicant.
Okay, so I guess the thing would be, if the complaint is filed and he's found guilty, that's when this would affect him?
If
Or-
he's charged with the, yes, if he's found guilty during the time he requests the promotion, between that time and the time that he or she would receive that promotion, then they would be able to knock them off the list.
Okay, let me say it another way. If the officer, a complaint comes in against me as an officer, and I'm being looked at, is that complaint then, just a complaint, held against me in this, would I be excluded? So I'm asking if the complaint has merit or the actual result of the complaint, meaning I actually did what was said about me.
If a misconduct complaint for which the punishment could be termination, if found guilty, has been sustained, so in other words, it's a sustained complaint by the Civilian Review Board, then that would be enough to knock them off the list, if there is a sustained complaint.
Okay, but just a complaint will not affect it at all?
Just the complaint would not, but if the complaint was sustained, it would.
Okay, that was my question. Thank you, Mr. Chairman.
Madam Speaker.
Recognizing the gentlelady from Carroll.
Thank you, Madam Speaker. Who asked for this bill? I mean, what was the problem we were trying to solve?
The Baltimore Police Department.
The Baltimore Police Department asked for it. Because you mentioned that it's all about a test and how you do on a test, but after reading the testimony, it sounds like there's two parts to the test, and the questions are put together by the police department.
Yes.
So it's a written test and an oral test. And from the testimony that I read, it said one of the reasons they put this together years ago is to make sure it was objective and it wasn't favoritism and crony whatever.
Sure.
So why did that change?
I think that the idea here again is that there may be people who don't take standardized tests as well as other people, and they wanted to be able to look at an officer's full resume, as opposed to just one component of that, and that's why they wanted to extend the list for promotions from just the top 5 people to the top 25% who apply.
So that's why the test. I mean, that's why the test is 2 parts. You know, it's questions so you can have a dialogue, and it's also a written part. I mean, I'm just questioning too why we're doing stuff like this in the legislature, and it seems like they put the testing procedure into place to stop a problem of favoritism in the hiring practice, and now we're sort of putting that back and taking objectivism away. So I'm just concerned, as my colleague said, why are we even doing this on the floor here today? Let the Baltimore City Police figure out what they want to do and take it out of the state's hands, and we don't have to worry about it on the floor here.
As the Baltimore City delegation voted for local control and voted enthusiastically for local control, and as this body pretty enthusiastically supported local control, I certainly appreciate your support for local control of the Baltimore Police Department.
So would this bill become null and void if that bill passed?
No. The laws are still transferring over, and in fact, in the local control bill, there's a process set up to move the statutes as exist right now over into Baltimore City statute.
In the future, would this kind of bill not come to us because it would be in the hands of the...
It would be in the hands of the Baltimore City Council and the mayor.
Thank you.
Gentleman from Western Maryland in the annex.
Thank you, Madam Speaker. I also had a question for the floor leader,
Yes, sir.
but I think it was in part just answered. So my question was, the bill that we passed previously in regards to returning local control, how does this bill mesh with that one? So if local control is returned to Baltimore City, does this bill just go away? But I believe I heard you say that over time the laws will revert to the local.
The laws will revert to the city, and the city council and the mayor would be able to determine the appropriate ways forward on these issues. But this would be the law until the city council and the mayor decided to change those laws.
And then at that point, their local laws would override this?
Yes.
Okay, thank you.
Is there any further debate? Hearing none, clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 102 votes in the affirmative, Senate Bill 752, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 862, arrest warrants issued by district court commissioners, recall by judge.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker,
Has everyone recorded their vote? Does anyone care to change their vote? If not, clerk will take the call. There being 135 votes in the affirmative, Senate Bill 862, having received the constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 914, Sheriff of Baltimore City.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker,
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 131 votes in the affirmative, Senate Bill 914, having received the constitutional majority, is declared passed. Special order calendar number 82. Clerk will read the bill.
Senate Bill 692, State Planning, Preservation of Agricultural Land Goal.
Recognizing the floor leader.
Thank you. Our questions have been answered. Be so much considered a reading of the amendments.
So ordered.
As amended, this bill is the same bill as HB 860 as passed by the House. The bill establishes a state goal of preserving a total of 1,030,000 acres of productive agricultural land by 2030 through the Maryland Agricultural Land Preservation Foundation, the Maryland Greenprint Program, the Rural Legacy Program, the Maryland Environmental Trust, the Next Generation Farmland Acquisition Program, and local land preservation programs. Amendment numbers 1 and 2 make technical changes. Amendment 3 expresses that the intent of the General Assembly is to extend the deadline to meet the state's agricultural land preservation goals set in 2002 as specified. Move the amendments.
Question for the House is the adoption of the committee amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill to its title? Recognizing the gentleman from Garrett.
Thank you, Madam Speaker. Would floor leader rise for a question, please? So the goal now is 1,332,000 or something like that. Where are you today? How many acres do you have in ag preservation? So how far do you have to go to meet your objective?
We're about 80% there.
What, 8?
80%.
80. Oh, okay. All right. That's good. I just was curious as to how far we got to go yet. So thank you. Thank you, Madam Speaker.
Thanks.
Is there any further debate? Hearing none, the bill is ordered to pass the third reading. Quorum call.
Madam Speaker,
Clerk will take the call. There being 136 members present, the House is still in session. Calendar of third reading, Senate Bills number 24. Clerk will read the bill.
Senate Bill 178, Maryland Police Accountability Act of 2021, Personal Records, Investigation of Law Enforcement Officers.
Madam Speaker.
Recognizing the committee chair.
There is a committee amendment, amendment number 423520.
Amendment number 1.
Move so much be the reading of the amendment.
So ordered.
Madam Speaker, this amendment would clarify the section of the legislation regarding what kinds of information shall be redacted from records that would be released under the PIA in this bill. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment has been adopted. Are there any additional amendments to the bill to its title? Recognizing the gentleman from Talbot in the annex.
Thank you, Madam Speaker. Could the floor leader rise for 2 quick questions?
Floor leader.
Good morning.
Good morning. Mr. Chairman, I think this may be the 3rd time you and I have discussed the exigent circumstances and also the time frame. So just so I'm clear, did we leave in the bill through that amendment the 8 a.m. to 7 p.m. time frame for no-knock warrants?
For no-knock warrants and only no-knock warrants.
All right, and then the other thing I would ask is, did the amendment change anything related to what authorization we could allow for a no-knock warrant? So under the bill, life or safety of the executing officer or another person who may be endangered or property subject to seizure may be destroyed, disposed of, or secreted. So did we get rid of one of those 2 standards to apply for a no-knock warrant?
What was passed in House Bill 670 was that the no-knock warrants would be only available for the life and safety of the executing officer or another person may be endangered at that time. That's still still when a no-knock warrant is allowed.
All right. So hang on 1 minute. Let me offer this amendment number up. Madam Speaker, I have an amendment at the desk, 503029-1.
Amendment number 1.
So much be considered the reading of the amendment.
So ordered.
So, Mr. Chairman, I strongly disagree with the idea that we should be setting business hours for no-knock warrants. But let me talk for a minute about the standards. So under the law, if this bill passes, the only application for a no-knock warrant would be for the life or safety of a executing officer or another person. Is that correct?
That's correct.
So we've eliminated through the committee's amendment, the most recent committee amendment, not this one that you offered today, but the one prior, we got rid of the part that said property, so drugs or maybe there's evidence that may be destroyed or disposed of. We've eliminated that as a standard for a no-knock warrant. Is that correct?
That's correct.
So let me give you an example and maybe get your thoughts, because I think it's important to talk about this through legislative intent. We have a law enforcement unit, a SWAT team, who has someone under detention. It's a suspect to a homicide. That homicide, after it was committed, they went back to their house, got rid of the clothes that had blood on it, cleaned up, left the house, and then was later apprehended. And so once the law enforcement unit determines through questioning that this person went back to the house, they are concerned because they think that maybe the evidence would be destroyed, and so they petition for a no-knock warrant. Why would we, through legislation, not allow, irrespective of what time of day, for the law enforcement unit to seek and go after evidence that would help secure a conviction?
Why aren't they just seeking a regular warrant?
Because they're concerned that the person living in the house, maybe a significant other, would be throwing away evidence, might be cleaning up the sink. I can think of 100 reasons why a unit every day defends the innocent by making sure they go after a homicide victim or some situation where they feel like they need the evidence and they need it immediately, and they also don't want to signal their intention of arrival.
So let me make sure I understand. What you're saying is that there has been a homicide. There's been a homicide, but the person went home after the homicide, or you indicated they were detained?
No, I'm saying that after a homicide, they go back. I'm using this as an important example, but they go back to the house after committing a homicide. They then later leave the house, are apprehended, and through the investigation, they realize that there's evidence at the house and that they're concerned that it's going to be secreted or disposed of, destroyed, et cetera. And so I think the example I'm giving you is one that I'm not making up myself. It's one that's being given to me by people very concerned about how we're limiting the no-knock warrant. So I'm going after the example of someone that we're trying to secure a conviction on, and up till now, no-knock warrants have allowed for the ability for law enforcement to do what they deem necessary to secure a conviction. Why would we not be after securing a conviction to the best of our ability.
So in the case of if there were exigent circumstances, where they had that information, the homicide had just happened, and they knew that the person was at the house, then they could go in fresh pursuit, I would argue, and be able to go into the house arguably without a warrant. And I'm happy to have anyone else agree or disagree with me about that, but I think that if they were in fresh pursuit, they could go into the house in that way. If this were a day or two later, then arguably a way that would be equally effective would be to get a warrant and to search the person's house. Mm-hmm. I think that would be an adequate response to knowing that material, or having at least a reasonable suspicion that the potential clothing was in the house during that time. They could get a warrant, they could serve the warrant.
Yeah, I mean, I think what you're saying doesn't necessarily mesh with the bill, and I did a little bit of homework on exigent circumstances, and my reading of this is that an exigent circumstance would include the concern for destruction of evidence or prevention of serious damage to property. And so while I'm no lawyer, and I'm sure you've got an answer for this, I believe that trying to remove property from a reason for a no-knock warrant speaks directly to maybe there's a large cache of guns, maybe there's a significant amount of drugs, maybe there's fentanyl, which just a very small amount of fentanyl can kill someone. So think about it through the lens of how quickly it could be that someone would destroy that. That's property. And we're eliminating law enforcement's ability to do anything other than, and surely we would want them to go in a no-knock warrant situation to protect a person's life and limb. That's surely exigent circumstances. But I'm talking about just the business of being able to conduct an investigation, apprehend a victim, secure evidence for the sake of conviction, and we, for reasons that are beyond me, trying to pass this law that put both hands tied behind law enforcement's back. Let me ask you another question, which is the bill seems to intend, by creating business hours on no-knock warrants, imagine a SWAT team, highly trained SWAT team, instead of showing up at 3 a.m. in the morning. This is a question, so let me pose the other example. It's the only other one I have. So instead of 3 a.m. in the morning, where they would surround the house, maybe park their vehicle a block and a half away, being well trained, certainly doing this at night is better than the middle of the day. Instead, the bill's requiring them to show up maybe when school lets out. Maybe when a family is walking the dog down the sidewalk. My son lives in Baltimore City. Maybe I'm driving down Martin Luther King Boulevard headed towards where my son lives on any given day, and all of a sudden there's a SWAT team that shows up, has to knock on the door for 20 seconds, and all of a sudden things can go wrong in 20 seconds, and there I am as an innocent citizen, not at 3 a.m. when I'm normally asleep, but rather during the busy part of the day, asking a SWAT team in broad daylight to conduct a very dangerous but important operation. And I'm just trying to figure out what the legislative intent. I've asked this question of you before, but I'm standing here today because I am lost as to why we think that it's safer for a SWAT team to show up in the middle of the day as opposed to 3 a.m. It's only safer for one party, in my opinion, and that's the one that we're trying to secure and apprehend. That's the only answer I can come up with. This is not safer for the SWAT team to show up at 2 p.m. in the afternoon. I'm just curious as to the legislative intent. I need to hear you articulate that one more time.
A no-knock warrant is the most significant warrant that I believe that can be effectively signed by a judge. This is where you are able to go into a person's house without any warning whatsoever. You're able to go into the house without any warning. That is kind of the top when it comes to what we look at with regard to our constitutional rights that we all have. Going into somebody's house with no warning requires that higher level of scrutiny. And that's why in this bill, we set out specific requirements for no-knock warrants, and why in this bill we set out the specific time frame when those no-knock warrants can be executed. The time frame during the day is there to make sure that if we're going to do a no-knock warrant and somebody's coming into the house completely unannounced, that there's no question that yes, they're less likely to be asleep, they're more likely to see what's going on, and they would see police officers coming into their house, and it would be less likely that people would be shooting at each other. So that's the reason why we've set these requirements on no-knock warrants and why we've put forward the bill. In the examples that you've laid out, and in a moment ago, you indicated that you even had a problem with a 20-second delay for a regular warrant to be served. That's the constitutional standard. That's the standard that the Supreme Court has set out to say, you got to knock, and then you wait the 20 seconds before you can come into the property. That is what the Supreme Court has basically lined out as the standard for how a regular warrant should be executed.
Right. Well,
that's in the bill, and that's how a regular warrant would be executed. What I rely on, and what goes to the legislative intent here is, in my mind, we do have extremely well-trained police officers who go into these difficult situations. They only go into these difficult situations because they've gathered the information that we're requiring in the bill. I think what we're requiring in the bill actually is consistent with what a good SWAT team is going to know and the information that they're going to have before they go into the property. So what we're doing is we're putting those safeguards in place, saying we want to make sure that you're doing everything that you are already trained to do before, in the case of no-knock warrants, you engage with these most serious of intrusions onto people's constitutional rights.
So, Mr. Chairman, thank you for your courtesy as we've had this discussion. I'm going to, Madam Speaker, speak on the amendment. The Talbot County has, and frankly all of our counties have, heroes for sheriffs and law enforcement. I talked to Joe Gamble, who's my sheriff in Talbot County, and it is without a doubt we have serious concerns for parts of this bill that tend to put harm in the face of law enforcement. It's going to have a dramatic impact on the way that we keep communities safe. I believe that this part of the bill and many parts of the bill that we're trying to pass here are going to eliminate proactive policing. This will essentially eliminate no-knock warrants for drugs, guns, gang violence, and it will have a devastating impact on our communities and the safety that we're trying to provide. Rule of law matters, and rule of law can only stand. Everything that we do as a legislature, whether it's legal or illegal, can only stand if we have the force of law behind it to make sure if there is a breaking of the law, that we give the tools to law enforcement and investigations to do their job. And so when I use the example of the SWAT team coming in the middle of the day, there is no way that is a best practice for law enforcement. They're going to come in at nighttime where they're able to conduct their business. It's serious business. We're not talking about your garden variety of criminal who we're going to show up at a no-knock warrant to their house. These are hardened criminals that need to be apprehended, and it is much safer. I think the legislature has this wrong. It is much safer to do this in the way that SWAT teams have been trained. They are highly trained. But once they realize that their job is no longer to show up over the darkness of night for the safety of themselves and others, but rather in the middle of the day, I can see law enforcement officers saying, I'm not going to do it. How can I do my job, keep citizens around me safe, keep myself safe so I can go home at night with the family? The other part that I would say to you is that we in the legislature, I know, want to address police reform. There is so much that we have heard this year, both in the House and the Senate, much of which there can be some bipartisan agreement with. Certainly, law enforcement would agree on some of this. But to take a policy that immediately puts our best in harm's way in a more dramatic way hurts our ability to do our job. And so, Madam Speaker, I would move the amendment in defense of law enforcement in the defense of safety, and most importantly, so they can do their job, so they can protect the communities that they serve the best way they know how, which is to be able to enforce the laws of the land, protect law enforcement in doing that. Please accept the amendment.
Gentleman from Charles.
Hey, colleagues. Madam Speaker, thank you. Colleagues, I was asked, did you guys resist this amendment? I think there are a few of us here on this floor who know what a forced entry or a breach is. And there's such an inherent danger by the operators when you go in. Muzzle cross, fatal funnel. For those of y'all that don't know where the fatal funnel is, it's that doorway. And then when you run through it, or the hole that you blow beside the wall, that's when you're the main target, when you have no cover. So again, we're talking about putting our officers in severe harm's way here. And there's something called IFF. It's identify friend or foe. It's something that's very important in any combat or any dangerous environment to know just exactly who you're addressing. Because when you go in these houses, you know, we use the term hardened criminals like they live alone. Like there are no children in the residence. Like there are no young ladies or young men who have nothing to do with this in the residence. If they got the proper address, if their leads are indeed right, we're talking about an extraordinarily hazardous situation that we are creating. And there are times when we should do that. The defense of property is never one of those times. It should be our public policy to put life above property. Because at the end of the day, these hardened criminals that we talk about, the ones that are out there that defend themselves and defend their drugs, they don't know who's hitting their door. Because as I've said before, nobody wants to get into a truncated firefight with MP5s and ballistic shields. Most anyone will lay down their weapons when they know that they are surrounded by well-armed and well-trained law enforcement. But when you kick the door in, they don't know if they're being robbed by another drug dealer. And a firefight starts. We talk about the danger of doing it during the day and citizens, you know, crossing, walking back and forth. At night, it's so much more dangerous. The fog of war is so tight because all you're seeing is like right beyond your nose. You're using flashlights, which we call mini targets in the military, because now everybody knows where you're coming from. All the things that make this wholly unnecessary. At the end of the day, what we have chosen to do as a body is say that we're not going to keep protecting property. We're not going to put the value of property or of a conviction over the safety and well-being of our police officers and the citizens in that building and in that area. See, when you fire a round, it doesn't stop when you want it to. That's if it even goes in a proper direction that you want. See, it penetrates. It penetrates walls. It penetrates ceilings. It penetrates floors. These are dangerous situations. You don't know what's on the other side of that wall. You don't know if there's a child sleeping on the other side of that wall. So while we have an obligation to go after the bad guy, we must make sure we do it safely. Going during the day is the safest time to do it. Going when they can see you, they know that you're not there to steal their drugs. They see the markings on your uniform. They clearly hear your commands. They're not shocked and wakened from a sleep. And believe me, with proper investigation, this can be done successfully. As I said earlier, you shut off the electricity. You cordon off the area. You shut off the water supply. You can't flush guns. You give them the 30 seconds. You let them know you're police officers. Then you go in. We cannot continue to pretend that mistakes don't happen, that the wrong address doesn't get kicked in all the time. And as I always say, at 3 in the morning, if the police get the wrong address and come to my door, I promise you there will be a firefight. Because that's all I know. Many other people in this room will probably say the same thing. Many libertarians in this room who don't want their buildings kicked into, who believe in the value and security of their home, will defend it with their life, as will I. So give me that opportunity to put my gun down, because I can trust and I can see that these are police officers. Because at 3 in the morning, ain't nothing good going on past midnight. You know the rule. I ask again, We reject this amendment for the reason that we're going to set a public policy that property is not as important as the value of our lives, of our citizens and our police officers. Thank you.
Madam Speaker, may I rebut from the annex?
The maker of the motion is in the annex, please.
Thank you, Madam Speaker. This will be my last word on this. Just to rebut my friend and colleague from Economic Matters, this bill without the amendment will cost lives. Innocent citizens, I've already made the case. SWAT teams are highly trained. The fact is that my sheriff shared with me that they served on a statewide homicide unit for 20 years, supervising drug and gang units, and only a handful of those cases in 20 years did they serve no-knock warrants during daylight hours, which brings me to the point that if you're going through what it takes to be trained to be a SWAT team member, best practice is to not show up in the afternoon, not only because they don't want to get killed themselves, that this is the safest way to conduct it, but they do it because they don't want to have citizens be put in the way, harm's way, and have them die from a stray bullet. We are dealing with hardened criminals, and they deserve no benefit of the doubt when it comes to when we show up, how we apprehend, and what it takes to secure a conviction. You've made the comment that property should never be a reason to have a no-knock warrant. I laid out an important case, not just because it's my idea, but because people in law enforcement are saying to me that for us to conduct an investigation to secure evidence, property is evidence, that we have to be able to do this when necessary to make sure that we take a hardened criminal off the street and make sure that person pays due time for the crime that they've committed. That's what law enforcement's about. This whole argument is academic. It really is academic. The legislature will or won't do what they're going to do. If this bill passes without the amendment, law enforcement will stop working these drug units, gang units, and gun units because they're not going to do the job with two hands tied behind their back. They're not. Nor should they. And the legislature should not be asking them to do that. What they should be doing is saying, look, we have a problem. Let's sit down together and work this out. It's not to ask law enforcement to stand there defenseless in the face of a very serious criminal situation. This is not the garden variety criminal that I'm talking about. You know and I know what we're talking about here. Serious criminals that require the no-knock warrant. Serious crimes. Drug, gang violence. These are the instances where we use no-knock warrants. These are the times where we take highly specialized SWAT teams, put them in place to do the job, which is no more, no less than protect the citizens of the state of Maryland. Move the amendment.
Madam Speaker.
Madam Speaker.
The maker of the move the amendment. All in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
To explain my vote, Madam Speaker.
The gentleman from Baltimore County in the annex to explain his vote.
Thank you, Madam Speaker. As I was sitting here listening to the debate, I look at things a little different, I guess. I'm thinking about a police officer has the ability, we're removing the ability for the police officer to do their job. We're sitting down here today directing them how to do their job. These are trained professionals. We're not. We should not be down here mandating laws to have no-knock warrants only between certain hours. Think about it. If we did the research deep enough, I'm sure we could find out that coming during the day, there's going to be more people in the house. There's going to be kids awake, eating breakfast possibly, eating lunch. So now we're going to have a no-knock warrant. They're going to be coming through the door, and they're not only putting the person they're trying to arrest, we're going to put all these innocent people in harm's way. Think about it. If they come in 3 o'clock in the morning, that person they're looking for is sound asleep. And I think that we're taking away the surprise element of the no-knock warrant. No one here, I'm sure, no one here wants to see anyone killed. But we need to let the professionals do their job. And that's why I'm voting support this amendment. Thank you, Madam Speaker.
Gentlelady from Baltimore County to explain her vote.
Thank you, Madam Speaker. I was touched when I heard my friend from Charles County say that it's the public policy will of this body to put life above property and money, because when my husband went to apply to carry his firearm, he had to give the state of Maryland his bank statements because his life isn't valuable to the state of Maryland, but his money is, and that's how he got approved. So I look forward to the constitutional carry bill that I'm going to put in next year, and I'm sure I'll have the body's full support in putting life above property. The other thing I want to mention is that there was a lot of talk about the no-knock warrant and making sure that we don't get it wrong. Of course, I never want us to get it wrong. And we thought of that when we worked on this bill. And I'll just tell you what we thought of. You can see it right in the bill. Not only do we need now a supervisor and the state's attorney to sign off on a no-knock warrant, but we also need a description of the evidence, an explanation of the investigative activities that were undertaken that allowed for the gathering to support this request, an explanation of why they're unable to get him or her in the daytime, an acknowledgement that any police officer who will execute the search warrant must have successfully completed the same training in breach and call-out entry procedures as SWAT team members, a statement as to whether the search warrant can effectively be executed during the daylight hours, and if not, what facts or circumstances preclude the effective execution in daylight hours, and a list of any occupants of the premises by age and gender, as well as indication as to whether any individuals with cognitive or physical disabilities or pets reside at the premises. We thought of that. We addressed that. This is a stellar amendment. It will keep your citizens safe, and that is why I'm green on this. Thank you, Madam Speaker.
The gentleman from Western Maryland in the annex to explain his vote. He changed his mind. Is any further debate? Gentleman from Talbot.
Madam Speaker, thank you. Just quickly, some anecdotal for everybody. The Talbot Sheriff Joe Gamble was quoted. Just so you know, in 20 years, no-knock warrants for Sheriff Gamble, there have been 2 shootings in 20 years. Standard warrants, there's been about 24 shootings. So the idea we're making the world a safer place with this amendment, it's just not there anecdotally. Maybe there's information that we don't have, but for Sheriff Gamble, Joe Gamble, who was quoted, 2 shootings in over 20 years, and about 24 shootings for standard warrants.
Anyone else to explain their vote?
Madam Speaker,
Gentleman
to
from
explain my vote, it was mentioned property over lives. You know, folks, we're not talking about Beanie Babies and skateboards. We're talking about stolen guns and heroin. 2 days ago in Annapolis, $1 million of cocaine was pulled off a boat. So while we're in here tying police officers' hands behind their backs for warrants, law enforcement's pulling 20 pounds of heroin 500 yards off the dock. That's what's going on. This bill makes it impossible to go after drugs and stolen guns, and it makes my communities less safe. That's why I supported the amendment. Thank you, Madam Speaker.
Is there any further explanation of the vote? Hearing none, the clerk will take the call. The amendment fails.
Madam Speaker.
Recognizing the gentleman from Western Maryland.
Thank you, Madam Speaker. I have an amendment at the desk, 683223/1.
Amendment number 1.
Thank you. This bill, as it has been reconstituted by the House Judiciary Committee, essentially deals primarily with 2 areas. One we just talked about, which is how police officers go out and undertake the dangerous tasks of executing search warrants and arrest warrants, whether they be no-knock or otherwise, how they put their own lives on the line to do their jobs, to bring to justice people who have violated some of the most fundamental rules of our society. The other part of the bill talks about how we deal with records of alleged police misconduct. So it's a little bit of a dichotomy. They're two separate things. They have a little bit of a relation together. This amendment that I have before the body today discusses when and how it is appropriate to allow for the dissemination to the public of records of alleged police misconduct. And I say alleged because I'm going to read the amendment. It's very simple. Doesn't require a lot of thought. If, after an investigation of a complaint described under subsection C of this section, which just refers to a complaint of police misconduct, use of force, other forms of misconduct, the police officer is exonerated. That means found innocent, didn't do anything wrong, or the complaint is determined to be unfounded. We investigated and we found out that we don't think there's really any basis for this complaint. We can't prove that this police misconduct ever occurred. The custodian of the records shall expunge, and that's a word we've all talked a lot about over the last 6-7 years, shall expunge the record without the filing of a petition or payment of a fee by the police officer who is the subject of the record to be expunged. What does that mean in common plain English? A individual makes a complaint about you as a police officer. Maybe it's someone you arrested who wants to say, I think she roughed me up. I think she put the handcuffs on too hard. I think he hit me, he bumped me. He committed some act of misconduct, that officer. And they lodge a complaint. And it gets investigated through these processes and procedures that we're putting into law. Whether it be an independent investigation at some level, whether it be an investigation that certainly has a high spotlight on it now in today's environment. People investigate and they make a final determination under the administrative system. This isn't about criminal charges. If there's criminal charges to be brought, that's a separate issue. Exonerated. I'm completely innocent. I didn't do anything wrong. Unfounded. You have no basis to register this against me. That record for a police officer should be expunged. It shouldn't be allowed to be disseminated to the media or to future plaintiffs or to, you know where it's going to be disseminated. It's going to be disseminated to the activists. The activists. We all love the activists, and there are an awful lot of activists buzzing around the state of Maryland and buzzing around Annapolis. And they're going to be requesting all of these records. And you're going to have police officers who were determined in a fair and balanced system to have done nothing wrong, but we still get the record that says we allege that you did something wrong. We get to find out, Officer Jones, it was alleged that you did something wrong. It was alleged that you're a bad officer. And I want you to think about this amendment in this context. How many people in this room, of both the majority and the minority party, have voted over the last 7 years to expunge records of regular citizens, our regular constituents, who actually did go out and commit crimes, who were convicted, who pled guilty to violating the law, and we made a policy decision that we don't think it's fair that follows you around for the rest of your life. We don't think that's fair that characterizes you to the public, that's available on a case search database that anyone can type in on their Google machine as we sit here. We don't think that's fair for regular citizens who committed crimes, who pled guilty, to continue on to have that on their record. But we do think it's fair under this bill, without this amendment. We think it's fair to take a police officer who was alleged to have committed misconduct or terrible acts and found innocent of those allegations. We think it's fair for that individual to bear that mark on their personnel records available for public discourse for the rest of their careers. That is illogical. If you vote to adopt that kind of a theory, that is simply illogical. It's nonsensical. It makes no sense to suggest that someone who pleads guilty, that someone who receives probation before judgment, that someone who has a record of criminal acts, that we want them to be rehabilitated, we want them to be revalued into society. We need to expunge, we need to clean their record so that no one can find out. But that a police officer who does nothing wrong has to bear that stain, has to bear that risk, has to live with that reality that when he or she applies for another job somewhere, they'll find out, well, you had 6 complaints made against you. They were all exonerated. None of them were real, but I don't know, 6 complaints. I read some of them. You were exonerated, but it doesn't sound too good. That officer, that innocent officer, has to bear those risks. I offer the amendment to you today to bring some balance, some semblance of logic to what we're doing here, as opposed to whose ox is being gored. We're upset with the police. Let's gore them. I'm upset with the bad police too. I think every Republican member of this chamber is upset with the bad police that have done terrible things in some very small, minor, unique circumstances. And they brought us all here. We're upset. But I'm not upset with officers who are exonerated. I'm not upset with officers who have unfounded complaints against them. I'm not upset with officers who tried to do everything right and still had someone make an allegation. Because sometimes making an allegation is smart if you're a criminal defendant. Maybe it'll get the state's attorney's office looking at your case a little differently. Maybe it'll increase your chances of being plea bargained. Maybe it'll increase your chances of getting a private attorney later to file suit, get a settlement for you. But when they're exonerated, the complaints are unfounded, they should be expunged. Thank you, Madam Speaker.
Floor leader.
Thank you, Madam Speaker. Colleagues, I would ask you to reject this amendment. Number one, just on process, the issue of expungement, I believe, we took up in House Bill 670, which is actually over in the Senate right now. Admittedly, what we did in 670 was say, no, these records cannot be expunged. And I understand all of the concerns you're raising. They sound totally reasonable. But what they assume is that we have some history of robust investigations into this misconduct. We got a peek into just a year of data for misconduct complaints into Baltimore City that were released very recently. And what we saw was dozens and dozens of complaints against certain officers, many of them, most of them, unsustained. And they were things like multiple repeated allegations of evidence tampering, making up evidence, lying on the stand, things that go at the veracity and truth that we need that underpin the criminal justice system when people might be incarcerated by these officers for years. And in fact, we've had to drop cases as a result of these discoveries. Further, it has been found that some of these problems were way up into the command structure. And so you can't even trust that what was happening was all above board. So we are asking the public to take a leap of faith with us. I understand it's an uncomfortable situation for some of the officers, but we do believe that by and large, when it is made known that it is unsustained, the public will understand what that means. And in fact, other states that have made this same leap and made these types of documents available to the public have not had the types of problems that you are suggesting are going to exist. And I hate to say it, but we are in an age now where the internet does exist, and even after data is supposedly expunged from criminal records, it often remains in private background check databases that have scraped this. It remains in Google caches and all sorts of places. The Internet Archive, the Wayback Machine, and the police have no problem with this themselves. If you ever read the weekly crime blotter and you see who was arrested in your neighborhood, sometimes with accompanying mugshots on Twitter, and that stuff is all done before they've been convicted. So I'm not suggesting that what's good for the goose is good for the gander, but I am suggesting the charge here is to reimagine policing. This is not a theoretical problem. The actual cases of showing rampant abuse often was happening with officers who had supposed unsustained misconduct. So that's why I think this amendment is unnecessary, it's actually harmful, and we don't need it. So please reject it.
Madam Speaker.
The gentleman from Carroll in the annex on the amendment.
Thank you, Madam Speaker. As the maker of the amendment alluded to a few moments ago, for several years now, since I've been down here, and this is my 7th session, we've been passing bills to expand expungement opportunities and to shield records from public view. And that's a public policy decision that this legislature's made repeatedly. And I have to tell you, I mean, there have been a number of times over the last few years where I've left a courtroom with a client after getting a null pros or an acquittal, and we've marched right into the clerk's office to get an expungement. Just last week, as a matter of fact, I mean, we passed a bill to take a look at partial expungements. So the expansion of opportunities for expunging and shielding records continues, except for police, apparently. Why in the world would we not give law enforcement personnel the same opportunity to have the same opportunity afforded to those charged with crimes? It really requires some mental gymnastics, it seems to me, to not support this common sense amendment. I strongly support it, Madam Speaker. Thank you.
Madam Speaker.
The gentleman from Hartford.
Thank you, Madam Speaker. Question for the floor leader. With this bill as drafted, what is the requirements for an individual to make a complaint against law enforcement?
You would file that with the local police department, and I believe that we actually deleted, not we, but that somewhere along this legislative process, the anonymous complaints were deleted. So you would file an ordinary complaint. It doesn't have to be notarized. We deleted that requirement, and it would go forward.
But there's no sworn statement there. It's just make a complaint, and it's on the file, and it's available to be requested through a Public Information Act request, even if it's not sworn to.
Yes, but let me also clarify one aspect of this. You're assuming that the person requesting this document is some random member of the public or the press, or maybe someone that wants to embarrass them. Part of the people looking at this history of complaints, sustained and unsustained, might be another police department that is thinking of hiring this officer. And so if you obliterate the records, I think you're causing a real problem that's going to undermine the integrity of our system. This was precisely the issue in the Anton Black case, where you had a problem officer being transferred between departments, and the full picture of that officer's issues was not being presented to the hiring department. That's the other part of what we're trying to clean up in this entire process, and I really think you're opening up a whole new set of problems if you include an amendment like this.
But you just mentioned, and again, I have great respect for you, how you champion expungement, and you've certainly changed my mind in a few points in our committee debates. But you just mentioned, even if it's expunged, the information still exists out there on the internet. So as part of a background check, even expunged, they could still capture that, correct?
But why would we subject our process to that sort of lack of clarity, the lack of predictability? I think if we just all are operating under the assumption that this is all happening above board and it is a matter of public interest. I mean, look, and the reason why it should, all of this, sustained or unsustained, should remain a matter of public interest. We are talking about a very unique set of individuals. We license many occupations in this state, probably too many. But this is not like a barber. We are talking about people who have the right to carry arms, they have the right to use lethal force, they have the right for arrest powers, and they are testifying in court where their honesty and whether they are conducting themselves in a constitutional manner matters far more than ordinary residents and citizens.
So therefore they don't deserve the presumption of innocence as all citizens do?
They deserve a system that says if their complaint is unsustained, that information is going to be right there. The public will be able to see this was an unsustained complaint. If that officer had 100 of them in 5 years, well, the public might draw a different conclusion about whether those were unsustained or not.
is there any provision in the bill that creates guardrails for individuals who made a complaint and then admitted that they falsified the complaint to have those removed?
All right, that's a very unusual scenario you are talking about. I mean, look, I've never heard of exactly that scenario happening. But again, all of the other guardrails of the process, in fact, it's part of the committee amendments that you're aware we adopted, was to do things like redact private medical information of the officers, redact the family information, redact the contact information, even redacting some of the witness contact information. But again, leaving the rest of the information out there so that the public has a full and fair picture of what's going on for people with the right to kill us.
Well, and the reason I raise these concerns is because, you know, we're talking about creating fairness. And so much of the conversation about police reform is that law enforcement has certain privileges that the regular citizen doesn't have, and we want to bring that into balance. But this does the opposite. This brings police officers out of balance with regular citizens, almost to a punitive fashion. And let me talk about this. And I don't mean to pick on Baltimore City. It's the only data I was able to pull, and it has a large sample size with this. In 2020, there were a total of 1,783 complaints against law enforcement. Of those, 1,359 were not sustained. Over 70% of all complaints against law enforcement in Baltimore City in 2020 were not sustained. That means 70% of all complaints against law enforcement will be put out there to attack or diminish an individual's reputation, their performance. Yeah, and then if we're questioning, well, maybe more of those should have been sustained, that's a whole different conversation. That's why we passed SB 600 last night, to make sure that these complaints are better sustained. So at the same time, we're saying we're putting a better system in place to make sure we're catching bad cops. Yet, we're saying we're going to, frankly, this bill shows we don't have any faith in the bill we passed last night. If 600 was the bill to make sure we are doing a better job catching bad cops and sustaining valid complaints, then we shouldn't need this. So I'm deeply concerned that we're creating something unequitable, something that almost punitive, not giving good police officers the same rights that we have as General Assembly members to not have our unsustained complaints about us put out there in the public. And yes, they're held to a higher standard than they should be. Everything you said about the roles and responsibilities is absolutely correct.
Sir.
Which is why we should give them the exact same respect that we give ourselves and we give every citizen in the state of Maryland. And we're all fighting for that type of equity. So I support this amendment by voting green on this amendment. Thank you.
For our leader.
Sir, I'll just leave you with the final thought. I mean, look, we are asking for a reimagining of policing in the modern era. This does include new expectations, new transparency, but essentially, we have seen exactly this problem emerge. We've seen it on bills about Yelp, right? And people leaving bad reviews for restaurant, things like this. The consumers of this product, the product being policing, again, people with the right to kill, arrest, send us to jail, violate our constitutional rights or not, we ought to have at least as much information about these people as we get for restaurants. I'm sorry, this is ridiculous. People can make this decision. This is a bad amendment. Please reject it.
Madam Speaker.
Maker of the amendment.
Thank you, Madam Speaker. I just have 2 points in rebuttal to that, to my friend, and honestly, my very good friend for years now, from Montgomery County. You said that, well, police officers are special. They're very special people. They're very unique. There aren't very many of them. They have to live to a higher standard. There are 188 members of the Maryland General Assembly. That's it. 188 of us that have this privilege and this responsibility. When someone makes a complaint about me, or you, or the Speaker of the House, or the President of the Senate, or any of us, they make a complaint in our system, our ethics system. You did something wrong. You breached a rule. You violated a public trust. And our ethics committee reviews that, and they conduct their process. Whether you think it's a good process or a bad process, it is the process. And they determine that's not true. That's not true. Delegate X, Senator Y, they didn't violate their public trust. They didn't violate the rules of this body. Those things aren't disseminated. If you are exonerated, if that claim is unfounded, nobody finds out about it. It doesn't go on the internet. Your political opponent doesn't use it against you. It doesn't go against you when you apply for a new job. It doesn't follow you in the Baltimore Sun and Maryland Matters till the day you die, and they put it in your obituary. If you didn't do it, you didn't do it. If that works for me, and that works for everyone else in this room, why in the world doesn't that work for the men and women who put their lives on the line as police officers in this state? And the second thing and final thing that I would say is, I appreciate, and I think it was just a rhetorical gesture, and I know there was no intent to it. Police officers aren't allowed to kill you. They don't wander around looking for people to kill. They have the lawful right to defend themselves and to defend us. And if they believe that a suspect, that an individual, that another person is acting in a way that they are a legitimate threat to the life, to the safety of another officer, of themselves, of a member of the public, we entrust them with that. And it's really not any different than the general right of self-defense that is enshrined in our Constitution and in our common law for all of us, that if we believe legitimately, objectively, reasonably, that another individual is trying to kill us, we can respond with appropriate force. I don't think that this amendment is difficult. I don't think that this amendment is a problem. You heard my friend from Harford County. The vast majority of complaints that are made, because people make complaints sometimes for not correct reasons, for not good faith reasons. And the vast majority of these complaints that are made, even in 2020 in the city of Baltimore, operating under a federal consent decree with a spotlight upon that entire department, 70% exonerated or unsustained. But let's keep those out there. Let's not let the police have them. I reject that logic wholly and completely. And Madam Speaker, I would move the amendment. Thank you.
On the amendment, all in favor signify by saying aye. Aye. Opposed?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. The gentlelady from Western Maryland in the annex.
Good morning, Madam Speaker. To my colleagues, good morning to you. Madam Speaker, I have an amendment at the desk. Amendment number 363520/1.
Amendment number 1.
Move so much considered to be the reading of the amendment.
So ordered.
Thank you, Madam Speaker. Good morning again to everyone. You know, I've only been here a short while now, and it's interesting how when I decided to be a public servant, to be in the midst of police reform with all that's been going on over the last year. So I'm hoping that my contributions to these conversations will bring forth good laws that are going to help all of us here in Maryland. The laws that we're seeking to pass for all of Maryland are going to be sweeping changes for all of Maryland. I'm hopeful that they're going to work in our favor for everyone. Police officers, constituents, black men, black women, white women, children, that they're going to work for all of us. We've got to put more faith and trust in our law enforcement, that they can do their jobs effectively. The bills that are coming forth, we're investing a lot in our police officers, or at least that's the potential, to bring men and women into the field who desire to be aspiring police officers. We're laying out the red carpet for them. We're going to pay for your schooling. We're going to pay for your degree. If you want to be a police officer, these are the things that we're going to do for you, to bring you into the field. But at the same time, we're saying these are the impediments that you're going to be faced with. It seems as if we're tying their hands, police officers' hands, behind their backs to do a tough job. We don't want any more lives lost. We don't want any of our constituents harmed by bad actors. We need to weed out those bad actors. But we have to make sure that the investments that we are putting into our police officers, current or new, are going to help them do their job effectively. So I'd like to reference a court case, the U.S. versus Banks, 2003. A young man by the name of LaShawn Banks was a known drug dealer. There was a warrant used to search his premises for cocaine and drugs. The police knocked on his door, announced themselves, waited 15 to 20 seconds before they had to break down the door to get in. They retrieved Mr. Banks from the shower. He claimed he didn't hear the knock. He pressed it further, but the U.S. Supreme Court decided that 15 to 20 seconds was an adequate amount of time before they could enter the premises. So my amendment is very simple, that we strike the 20 seconds based on the decision by the Supreme Court and change it to 15. I've often heard my colleagues say, and reference Supreme Court decisions, that tends to be what guides us in the laws that we're writing. We reference the Supreme Court based on their decisions. So with that, I say that we strike the 20 seconds and change it to 15. I move the amendment.
Vice Chair of the committee.
I'd ask the body to resist the amendment, and the standard is in US v. Banks. It is. They did look at a situation where they were looking at 15 to 20 seconds before entry, from the time of the knock to the time when they could enter the property. The bill, as it's before us, has 20 seconds. The committee believes that the 20 seconds is the appropriate time, and that was a compromise position with the Senate. And so for those reasons, we ask you to resist the amendment and vote red.
Any further debate?
Yes, Madam Speaker, thank you. So, again, I reiterate the fact that we often reference the U.S. Supreme Court in the decisions that we make and the laws that we're putting forth. With the more training and resources that we are providing to our police officers and those who desire to come into the fold of being in law enforcement, 15 seconds is an adequate amount of time before the law enforcement officer is forced to enter the home. With the good training that they are provided, when they knock on that door, I'm sure every police officer is going to hopefully be mindful that they don't want anyone to be hurt or harmed that doesn't need to be when they're trying to apprehend a criminal who's selling cocaine, who's selling heroin on the streets that we know do harm to our communities. So when they knock on that door, I'm hopeful that with the good training that they are being provided, with the training that's going to be poured into them, that they can know that before they enter that home, there may be someone in here, a small child, a mother, a grandparent. Knock on that door, have that thought in their mind, and enter the home or the residence when that person doesn't knock. So I press the amendment, Madam Speaker.
On the amendment, all in favor signify by saying aye. Aye. Opposed?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Gentleman from Anne Arundel to explain his vote in the annex.
Thank you, Madam Speaker. For those of you who may be like me, hopefully there's one or two of you that still have an analog watch. I ask you to take a moment and look at it.
He's trying to demonstrate 15 seconds. Demonstrate 15.
Well, if you had been listening, everyone, I asked you to look at your watch. I heard people saying, what's wrong? What's wrong was that was 20 seconds. That was a lot of time. That's a lot of time for someone who might be in a Crips gang, which is what Michael Banks was in 2014. Michael Banks was in the Rollins 90s Crips gang, and that's why a warrant was being served. We've heard much about the Supreme Court case. What is the appropriate amount of time to wait, to give warning, to give a defendant time to get a weapon, to shoot someone who is serving a warrant? We had time here for people to start wondering what's going on. That's at the exact point. I also wish to point out the Supreme Court case didn't say there had to be at least 15 to 20 seconds. They said 15 to 20 seconds was sufficient. That was the floor that was set in the Supreme Court case. 10 seconds might have been, if that had been the facts of the case, might have also been sufficient. So we've gone to the top end of what the Supreme Court ruled in United States versus Banks. I encourage everyone to look at it. It's a short opinion.
Gentlemen's time is up.
8 pages, 124 Supreme Court.
Gentlemen's time is up. Gentlemen's
This is
time
important.
is up. You get 2 minutes to explain your vote.
Well, I marked the button trying to engage an argument, and no one recognized me.
John Lay from Baltimore County.
Thank you, Madam Speaker. To explain my vote, I'm going to be voting green on this. I know we had in the bill that if there was exigent circumstances, then the officers...
I had to interrupt. You have to vote, put a vote up on the board in order to explain your vote. You can't explain something that's not up there.
Sorry about that. Thanks for catching that. I would have had to do a vote change later. I apologize. All right, now I'm a green vote. And the good gentleman before me, my ranking member on Judiciary, he timed that 20 seconds. And a lot of people, when we talked about this part of the bill, said, well, if you can hear a gun rack through the door, then you can go in. You don't have to wait the full 20 seconds. And just to explain to the body, if you come to my home, you won't hear a gun rack. And that's because the gun is already chambered. And I can get off a lot of rounds through that door in those 20 seconds. And so can the bad guys. Thank you, Madam Speaker.
Madam
Speaker.
Gentleman from Baltimore County.
Thank you. And just really brief, I support the amendment, and I appreciate the delegate from Western Maryland. She made the point about the prior Supreme Court case. And I think we all sat here very intently and listened to how the Supreme Court case, when the bill that dealt with parole for juveniles was used to support the argument. And here we're just simply trying to have some consistency. And I agree, if that 5-second difference can mean life or death or mean safety for our law enforcement, then I support the amendment, and I appreciate it. Thank you.
Any further explanation of one's vote? Hearing none, the clerk will take the call. The amendment fails. Gentleman from Baltimore County.
Thank you, Madam Speaker. I have an amendment at the desk. The amendment number is 713820. Move so be considered the reading.
So
Thank you.
ordered.
Move so be considered the reading of the amendment. Thank you kindly.
Again, so ordered.
This amendment discontinues the use of no-knock warrants. I'd like to start with a story of a man from my district. In 2004, a man named Matt Knoll was halted on a routine traffic stop. As Matt and the officer spoke, the officer noticed a single pill in Matt's car and inquired about it. Matt advised the officer that he had an addiction issue, that he was trying to manage. A trash rip was executed at the home of the Knoll family, and trace amounts of narcotics were found. Although law enforcement saw no signs of distribution, a no-knock search warrant was issued for the Knoll residence. A SWAT team of 16 officers subsequently showed up at the Knoll residence. A flashbang grenade was exercised and the door was battered down. In response to the noise, Matt's mother, Cheryl Knoll, grabbed a legally registered handgun she kept nearby and held it at the ready while the SWAT team burst through the bedroom door. Charles Knoll, who was asleep on the bed, sat up, and before he could utter a word, he saw 2 muzzle flashes. He looked over to see his wife beginning to go down. His wife, Cheryl, said, "They shot me in the chest." Officers then yelled for Cheryl to move away from the gun, which she had dropped. Charles Knoll testified that his wife posed no threat, that she was incapacitated and could not comply. Police then fired a third and final shot downward into the center of Cheryl Knoll's chest. Cheryl Knoll, who friends described as a committed wife that taught at the local Sunday school and worked for the Baltimore City Department of Public Works at the Back River wastewater treatment plant, was killed in her bedroom by her own government. You can find Matt Knoll on Facebook if you want to look him up right now. He frequently shares pictures of his mother, who died more than 10 years ago in a no-knock warrant. Come on now. No-knock warrants create high-pressure situations that frequently provide for no peaceful outcome. Frequently, residents procure a weapon in self-defense, suspecting intruders in their homes. This is dangerous for average people and dangerous for police. Frequently, police are shot at or shot. Being that individuals are usually disoriented, which happens by design, the warrant can easily lead to the death of innocent residents. And this was the case in Montgomery County as police attempted to execute Maryland's insane gun laws, and they killed a man. His name was Duncan Lemp. It was reported to police that, allegedly, Duncan Lemp was the owner of a weapon that was on a statutorily prohibited list to own. Additionally, it was alleged that Duncan was statutorily prohibited to own any firearm, as he had allegedly committed a crime as a juvenile that would have prohibited him from owning a firearm. On March 12, 2020, a no-knock warrant was executed on the home of the Lemp family. One officer breached Duncan's window while the second moved into position. As it happens with many no-knock warrants, Duncan grabbed a gun, which he kept near his bed for self-defense. 5 shots were fired. All 5 hit Duncan, and he was killed beside his fiancée, who was pregnant with their first child. It was found that both allegations of the warrant were actually false. The rifle that Duncan owned was a fully legal rifle. Additionally, he had received a background check from a nearby gun shop, certifying him by the state as a fully legal gun owner. On March 12, 2020, Duncan Lemp was killed in a no-knock warrant. Not only did he not commit a violent crime, he committed no crime. The next day, on March 13th, 2020, a warrant was executed at the residence of a young girl in Kentucky named Breonna Taylor. The officers did indeed knock in this warrant, but the warrant did result in a breach of the door. This is the third story I'm telling today about the execution of warrants. This is also the third case in which an occupant drew a weapon in self-defense. An officer was shot by Taylor's boyfriend. 32 shots were returned by law enforcement officers. Breonna Taylor was shot 6 times and killed. Taylor's death was terrible. Murals, protests, and political movements were all created in her name. But as a matter of policy, and we are policymakers, so we should consider this, It is important to note that while the warrant that was issued for the Taylor residence, the warrant that was executed was not a no-knock warrant. I spoke to Duncan Lemp's family of Montgomery County. The Lemp family was thoroughly frustrated. Their son was killed on March 12th in a no-knock warrant, and the entire nation ignored them. The Lemp family called their councilman. They called their county executive. They called their delegates, their senators, their congressmen. And in a time when the entire country was talking about no-knock warrants, nobody would talk to the Lemp family. Breonna Taylor was killed less than 24 hours in a knock and announce warrant, and she was made the discussion of the entire country. It begs the question, why was Duncan ignored and Breonna was immortalized? I would ask my conservative friends, what does it say about our country if it's popular to ignore the wrongful death of a person in a no-knock warrant one day when it's politically inconvenient, and on the next day carry the banner of reform when there is a political benefit? What does it say when our political system exploits the principle of an issue, and after an election, they completely ignore it? And the worst part is, all the people that advocated and used Breonna Taylor turned around and they didn't do it. All the agitation and the inflaming of communities. Do you remember the riots? The people in the street? The fundraising emails? The campaign promises? Madam Speaker, I got a snapshot of the Maryland House Democrats' Twitter, January 22nd, 1:35 p.m. Police reform priorities. Banning no-knock warrants. And nobody did it. And I'd also like to ask my conservative friends, where is the left going to go with this? What are we going to use these warrants for? How many jurisdictions are going to turn into Baltimore City where we're not even prosecuting drug charges? What are we going to use these no-knock warrants for in the future? Can anyone here raise their hand and say we're going to use these no-knock warrants for drug cases? We're going to use them more for drug cases and less for the criminalization of gun ownership? I would urge you to consider the actions of President Joe Biden, whose Justice Department has lobbied the Supreme Court to rule that police officers don't need a warrant to enter your house and confiscate your guns. What do you call a no-knock warrant where you don't need a warrant? I have a word for it. It's terrifying. I'm terrified. If your crime is you own a gun legally and your government can kill you and the entire country ignores you, I'm terrified. I'm terrified. Madam Speaker, it's the role of the conservative to protect the individual from the state. Our policy should be guided first and foremost in the protection of innocent lives, period. I'd like to ask my colleagues, what are we going to say from here? Because this is going to happen again.
Can I ask you not to scream?
I'll
Some
reel
of
it back,
us have
Madam
very
Speaker.
sensitive
I will.
ears,
I will.
including me, and you
I
still
will.
put
Thank
there-
you.
Okay,
Thank you.
Please. Thank you.
I would ask my colleagues, what are we going to say from here? I'll move it away a little bit. I got you. I'm sorry. I'm working on 1 hour sleep, Madam Speaker. What are we going to say to the public from here? Because this is going to happen again. It's going to happen again. It's going to happen in this state. Whose district will it be? What do I go and say to the Lemp family? What do I say to the family who was completely ignored by their representation? What do I say to the Knoll family, to Matt Knoll, who every day shares pictures of his mother who died more than a decade ago? I don't think I'll ever get an answer to that question. And I think that's the reason why, Madam Speaker, that for the first time ever, more than 50% of conservatives and Republicans are opposed to the use of no-knock warrants. Madam Speaker, I stand today with Cheryl Knoll and the Knoll family of Dundalk, family of Duncan Lemp, and objecting to no-knock warrants. I think we're making a policy mistake that we'll look back on and realize it was a mistake, and I'd move the amendment.
The gentleman from Montgomery in the annex on the amendment.
Thank you, Madam Speaker. On the amendment, I would ask the body to resist this amendment for all of the reasons that have been previously stated. One piece of this that I think is important that we often talk about, and that is I have a good relationship with the delegate from Baltimore County. With that said, I think we really need to be very careful with the words that we use, because I have consulted with the delegates from District 15. And nobody reached out to us. Nobody reached out to us on this particular issue that he's alleging with the Lemp family. Nobody reached out to us. So when we're speaking about representation and being represented or not being represented, I think it's very important that we have our facts straight first. I'll be resisting this amendment, and I urge the body to resist it as well. Thank you.
Is there any further debate? On
Madam Speaker.
The gentleman from Frederick.
Thank you, Madam Speaker. Briefly, I rise in support of my good friend's amendment, and I want to just mention that this is something that is bipartisan, and as my good friend from Charles County has said, as well as my good friend from Harford County, that when someone from the government arrives at your house, they need to tell you that they're there, that they're the police. They need to announce their authority. When they do not do so, they risk endangering everyone's lives. And I'll just point out, and I love history, and this goes back to the Magna Carta, when the king's troops could come at any hour of the day and burst into the house of those who had offended the crown and drag them off. Now, I've talked to my local sheriff and my police in my jurisdiction. They don't use no-knock warrants. In fact, absent exigent circumstances, the proper procedures don't normally include this process. So I rise in strong support of ensuring that we as citizens of America and of Maryland are informed at all times of the day who it is that is coming into our home with guns and endangering our lives. Thank you, Madam Speaker.
Recognizing the committee chair.
Thank you, Madam Speaker. I'd ask the body to resist the amendment. The committee did address this amendment during our voting session. The committee chose not to accept this amendment. And I'll go further in saying that we have put significant guardrails and restrictions on no-knock warrants in the bill. We've put in restrictions that treat no-knock warrants with the seriousness they deserve, and focuses them on issues that relate to an imminent threat to the life of a person. For all of those reasons, I ask the body resist the amendment.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails. The gentleman from Cecil in the annex.
Thank you, Madam Speaker. Have an amendment at the desk. Amendment number is 333525-1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
For the benefit of the body, in one sentence, what this amendment seeks to do is to forbid persistent aerial surveillance, put in plain terms, warrantless dragnet from the sky. I'd ask if the committee chair could yield for a question or two.
Committee Chair.
Good morning.
Good morning. I actually was inspired to put in this amendment by some recent actions taken in Baltimore City. And just for the good of the body, I wanted to ask you a few questions about Arnold Ventures. It's my understanding that there was a beta program to do this type of surveillance in Baltimore City. And if you could you outline what the end result from a policy standpoint, and then ultimately what the courts decided based on that Arnold Venture surveillance?
They're not using them.
Correct. Okay. Yeah. So this is one of those weird nexuses where private industry attempted, I want to stress attempted, to team up with government to do unchecked and unwarranted surveillance on citizens in Baltimore City. They actually went on to try to fund a candidate for mayor. Didn't go well. That candidate did not, I don't even believe, place in the top 2 or 3. And it was a policy decision by Baltimore City to ban that surveillance. And I might add that, we throw a lot of words around down here, but when private industry joins up with government to do things like that, unsavory things, that's what I call fascism. I want to talk about what this amendment does, because it is very nuanced, and I want to make very clear what it does and what it doesn't do. It defines aircraft by saying that any device used or designed for navigation of or flight in the air. So this just isn't helicopters or drones. It includes anything that's above us. It could be a dirigible blimp. Could be an unmanned aircraft. Some might say that the technology doesn't exist yet, or that we can't listen in on people's conversations, that we can't track your movement based on facial recognition. But in some instances, we can do that now. And I would go on to point out that Arnold Ventures touted their product by saying, we can do 32 square miles of surveillance for 40 hours. Folks, that's the technology that existed yesterday, all right? We make policy down here on today, but also tomorrow. This is one of the most rapidly accelerating technological ventures on the planet. And we have to protect our citizens from that type of surveillance. To go on more about the amendment, it defines that persistent aerial surveillance means video or concurrent images to depict a person's actions over time. That's key. And some of you might say, well, hey, we got to get the bad guys. They're out there. We have these tools. We should use them. But there are exemptions on this amendment, and that's why I want to point those out in order. If you have your floor system up, go ahead and click on it, and you can follow along. You may use these tools if the following is occurring. 1, you have a valid search warrant. 2, on location for executing an arrest warrant. 3, you are in pursuit of a criminal. 4, you are assisting a search and rescue. 5, locating an escaped prisoner. 6, you are preventing bodily harm or destruction of evidence. And then 7, the Secretary of DHS determines it is necessary because of a terrorist threat or attack. I really want to give my hats off to Bill Drafting for forming this amendment because it does 2 things. 1, it protects us from this unchecked dragnet on regular, law-abiding, everyday citizens. But 2, it preserves the ability to go after evildoers. And that's ultimately what we seek to do. Now, during this debate, I'm sure that there's going to be reference made to a lower court that did believe that this type of surveillance that occurred in Baltimore City was legal. I would like to challenge that and say that this has not gone to the Supreme Court yet. And if we want to talk about the tyranny of technology, we have to look no farther than a 2001 case of Kilo versus U.S., where it was determined to be a violation of the Fourth Amendment that thermal imaging, a technology that today could be mounted to a surveillance plane, constituted the breach of the home. That thermal imaging needed a warrant. Guess who cast the deciding vote on that decision? Justice Scalia. Folks, it is possible in the very near future that we will have technology that can track from some sort of aerial plane, dirigible, etc., all of your movements, all of your conversations, your cell phone, what's going on with it. Some of these things are already here today, but the technology will exist to roll all of that together. Okay? And then in that instance, everyone is a potential target. Anything you say or do could be your proximity, where you are, what you're doing. It's scary, folks. And we as policymakers have to make decisions today that will impact us tomorrow on what we hold sovereign. There's already the technology to peer inside your house, to peer inside your car. Okay? And entrepreneurizing companies, corporations could use that information. In most cases, they already are. But when they get together with law enforcement and start doing that, everyone potentially becomes a criminal. I hope that there's some debate on this issue. Again, as the previous maker of the amendment alluded to, this is a bipartisan issue. And I would ask the body, I would urge the body to follow the example of Baltimore City and their wisdom in determining that right now, we don't want these sort of things in our community. And I'd ask for a green vote. Thank you, Madam Speaker.
The committee chair.
Thank you very much, Madam Speaker. I'd ask the body to resist the amendment. The committee dealt with this amendment as part of its discussions on this legislation and rejected this amendment that was in the same form as what was offered to the committee. Furthermore, there is an existing bill in the Judiciary Committee with exactly the same language, so I don't think the bill drafter had to go very far to find this. For those reasons, I ask the body to go red. Thank you.
Gentleman from Baltimore County who will lower his voice.
Thank you, Madam Speaker. I will most definitely lower my voice. I rise to support the amendment today. I think it's a great amendment. I think it's an important amendment. I'd like to talk a little bit about the history of this program. If you don't recall, the use of this technology in Baltimore City happened after the riots after Freddie Gray. And it was not disclosed to the public that this technology was in use. It was operated in secret without any knowledge to the public. And every time that this technology has been implemented around our country, that is how they put it in place. The operator of the program worked with the local jurisdiction, they put it in the sky, and eventually the public found out. And when they did, they were rightfully incensed. In every single case around the country, they said, you cannot operate this program without a warrant. And they completely shut it down. And they adopted policies to say, if you're going to operate mass surveillance, if your government is going to operate mass surveillance, you're going to use a warrant. In fact, states that have never even used or touched this technology have adopted these laws. So there has been a bill for this issue for several years now, and unfortunately we can't get any attention for it. I think it's the right thing to do. It's clearly having a warrant for Baltimore City or any jurisdiction or the state of Maryland to operate mass surveillance and record the entirety of their city all day long is clearly something that needs a warrant, and that's why I'm supporting the amendment today.
Is there any further debate? On the amendment, all in favor signify by saying aye. Opposed?
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails. Gentlelady from Carroll.
Well, thank you, Madam Speaker. I had a couple questions for the floor leader.
Chairman of the committee.
Good afternoon.
It is afternoon. I had a couple questions about Section 4-101, which has to do with the State Public Information Compliance Board and the information that will now be available to the public. Can you just explain what kind of information this bill would release as it regards with regard to police officers? What it is currently and what is proposed in this bill?
I'm sorry, you're asking about the public information, the board?
Well, about what's going to be releasable on police officers.
The information, there will be requests that go into a custodian of records. The custodian of records would be able to then determine what would be released. There are some things for which a custodian can deny inspection, including if the inspection would interfere with a valid and proper law enforcement proceeding, deprive another person of a right to a fair trial or an impartial adjudication, constitute an unwarranted invasion of personal privacy, disclose the identity of a confidential source, disclose an investigative technique or procedure, prejudice an investigation, or endanger the life or physical safety of an individual. Furthermore, we have, in our previous amendments, we've allowed for the redactment of some information with regard to medical records and information regarding personal information of the officer.
And those amendments made it so much better. I say much better. They obviously should not have been included, their medical records. But is it true that currently police misconduct investigations are considered all personal records and thus are not available for request under the public information?
That's correct. Right now they're considered personnel records. These would say that they are not considered personnel records unless they are related to a technical infraction.
Thank you. And what exactly is a technical infraction?
It's in the definition section of the bill. I like reading for the rules, and I like killing a little time while I'm flipping pages in front of me while I'm reading the rules. A technical infraction means a minor rule.
Well, I can just tell you the part that's of concern to me.
Okay.
It does describe it in the bill, but it also says a technical infraction is not otherwise a matter of public concern, and that's so broad. So it just seems like anything could be a public concern. So how does that...
It strikes me that when we had the debate on this legislation, when I think even last week, we addressed this issue, the critical part, and so I'll read it because the and is important. The technical infraction means a minor rule violation by an individual solely related to the enforcement of administrative rules that, 1, does not involve an interaction between a member of the public and the individual, 2, does not relate to the individual's investigative, enforcement, training, supervision, or reporting responsibilities, and is not otherwise a matter of public concern. You need all three.
You need all three.
You need all three.
Okay, thank you. The other thing that came up, I guess, during the discussion while back today, or about an hour ago. It was about expunging of some of these complaints if they were not valid. And it was also came out that one of the changes that's been made in this bill is that complaints are not filed under oath anymore. And what was the reason for that change?
Some of the complaints are not what again?
They're not filed under oath?
They're not filed under oath.
Mm-hmm.
The complaints are submitted. They're submitted under the structure that's being proposed to either the police department or to the police accountability board. They are not sworn under penalty of perjury. We've had debates in this chamber for many, many years that talk about why the belief that there was, in fact, a notary requirement at one point that stood in the way of people actually being able to file complaints because that was seen as being overly burdensome. So it allows them to make the complaint, and then the police departments would be able to investigate those complaints. They investigate the complaints, and then people would, yes, be able to see after the fact that the police officer was exonerated or the complaint was unfounded. And quite frankly, we think that makes the process stronger because it demonstrates to people that those complaints, in fact, were unfounded, and it demonstrates that the police departments take those complaints seriously.
But they're all available now through public information.
They would be available subject to the restrictions that are already available in the law.
Restrictions, I think, as you said, they're pretty broad. So under this new proposal, would any and all departmental charges against an officer, such as an accident with a vehicle involving minor departmental charges of late, if somebody's late or tardy, would they be released? Is that considered a technical infraction?
I think a lateness would probably include a technical infraction because it doesn't involve an interaction between a member of the public and the officer. And Madam Speaker, I guess I do believe, I'm not forgetting that we actually had this debate a couple days ago on second reading, so these are some of the same questions. The second issue with regard to a car accident, I don't believe that would necessarily go to the individual's investigative enforcement, training, supervision, or reporting responsibilities. A simple traffic accident, I think, I would also argue, may or may not be a matter of public concern, but I think I think on a case-by-case basis, a car accident may be a technical violation.
You believe that would be a technical violation?
I believe, depending on the circumstances of what happened there, and depending on whether a complaint was actually filed against the police officer related to the accident. I think what is more likely to happen is a lawsuit's likely to be filed against the jurisdiction based on whether or not the officer was liable for or negligent in driving the vehicle.
Thank you. Was there any discussion in the committee about whether or not there would be a concern that this may lead to more frivolous complaints and more volume of complaints than we already have?
That's been part of the conversation that we've had for years related to issues connected to the PIA. And I think that where we've come down is we have said that we need to make sure that we do everything we can to build confidence, greater confidence, that when complaints come to the police department that they are investigated well, and it's clear when a person is being exonerated or a complaint's unfounded or a complaint's unsustained or a complaint's sustained, that this process works so that people in the public can know and have confidence that the process works, so that they can have more confidence that their complaints are taken seriously.
And where else in the public sector do we have this same policy? What other types of, teachers, legislators, correctional officers, where anywhere else in the public sector at all do we have the same kind of supposed transparency where every complaint against you is now available in the media?
I think that there is a distinction between police officers and any of those other occupations.
Thank you. I appreciate that. I think they're all important, and I think what's good for the goose is good for the gander, and we should be doing the same thing in our body. We've already had that discussion here on the floor today. I have an amendment at the desk. Amendment number 893223/1.
Amendment number 1.
So be considered the reading of the amendment.
So ordered.
Basically, this amendment will limit the scope of police personnel records that can be made public. And it will say, for the purpose of this section, the following types of records are personnel records: the records of technical infractions and records of unsustained or unsubstantiated complaints. As was mentioned earlier on a different amendment, 70% of the complaints that come out are unsubstantiated. And just think for yourself, in whatever role you play in the real world or here in the legislature, if someone makes a complaint against you and it's unsubstantiated, do you want that to be available forever in the media for anybody to get to all these unsubstantiated complaints? Complaints must no longer be filed under oath or subject to the rules of perjury. Thus, citizens with grievances against police officers will be able to file totally specious, malicious complaints against men and women who put their lives on the line every day to protect our citizens. And these complaints will be available to the press. The reputations of some of our finest will be destroyed. Their families will suffer from the notoriety. And once the false information gets onto the social media, it could be their children will be teased and bullied in school. This bill is mean-spirited and simply not warranted. I've just noticed, we've been talking about this police reform lately, and when I read the paper every day, I notice how it's constant badgering of police officers, all the things they do wrong. And barely do they ever write anything about all the good that police officers do every single day to keep us safe. Every day, our police officers do work of heroism. And it seems to me we're just opening up for more of that. I guess people like to read bad information and little things, and this just bothers me that this is going to be even more available to the press. We don't use these standards anywhere else in the public sector. For us, for teachers, for correctional officers, and I'm not asking that we do that because they're unfounded. These are unsubstantiated complaints. We have a lot of testimony on this. The Maryland Chiefs of Police, Maryland Sheriff's Association, all oppose this. They support the efforts to enhance law enforcement transparency and accountability, but this is not part of that. The broad release of investigative and disciplinary files by anyone at any time may risk detrimental effects, and there's no way to prevent redisclosure or publication of this information. Evidently, last year you all in the Judiciary Committee had a different approach, making exceptions to the rule for very specific situations and circumstances, and I think that would have been supportable. In situations that were involving things like the discharge of a firearm or use of force and sexual assault, some very, very important issues. But this bill before us today is not limited. It is so broad. And basically, this amendment would make sure that it's only substantiated cases that are put out to the press. We also have opposition testimony from our Fraternal Order of Police, basically saying the same thing. The Maryland and federal rules of evidence prohibit past misconduct from being presented at trials because our society recognizes the irrelevance of such material and the highly prejudicial nature of such material. Exposing these personnel files will only serve to embarrass law enforcement officers for prior conduct, regardless of whether that officer has ever been adjudicated as guilty of what was previously charged. We don't allow this anywhere in any other kind of trial for anyone else. It's just law enforcement that we're going to be doing this for. This bill has one purpose in mind: to discredit, embarrass, and abuse law enforcement officers of their reputation and livelihood. If such a need is warranted for law enforcement community, then why not our legislators and government employees? This is coming from the Fraternal Order of Police. Making misconduct allegations subject to public information would make a mere allegation and complaint against an officer not part of a personnel record, and therefore make it subject to inspection and publication. I believe that is wrong, and this bill is way too broad, and therefore, Madam Speaker, I'd like to press my amendment. Thank you.
Committee Chair.
Thank you, Madam Speaker. I would ask the body to resist the amendment. This would put us in line with several other states that make police discipline records generally available, including Florida, including Washington State, including states across the country that have done this. And channeling another member of the body from Prince George's County, the world has not come to an end when these things have happened. It did not result in children being vilified at school. For all of these reasons, we'd ask you to resist this amendment.
Gentleman from Talbot.
Thank you, Madam Speaker. This amendment is I mentioned it last night. Our districts are very different, and what's going on in one district in one part of the state is different than another district. But this amendment is a big deal in my district. We've got police forces almost at half staff. Cambridge, Easton, Dorchester County, they lost a deputy last week. The officers are watching this, and I'm not sure about the interactions in the other districts, but I know there's a huge fear amongst active police officers about this very issue. And there are other issues that they're worried about. I know everybody's heard about them, but this particular amendment is a very big deal. And our local law enforcement, we call them small town offices, whatever, they're hurting. And they're not able to fill open positions. They can't even do community policing. They can't do the kid programs to get to know the communities. We want them to be better police officers. They can't even keep up with the paperwork they have right now, and they can't recruit because of fear of their personal information being posted all over social media. Now, there may not be a record in other states about this being a problem, but it is a problem right now. Right now. And I didn't do any research on this. I didn't call around. I was just drinking coffee at the convenience store, and the police officers are talking to me about this. And so if they're talking about it right now, this is real-time stuff. So please support the amendment.
On the amendment, all in favor signify by saying aye.
Aye.
Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails.
Madam
Gentleman from Frederick.
Thank you, Madam Speaker. I was informed that the gentleman from Hartford County would be proceeding next. I don't want to be out of
I have
order.
the gentleman from Frederick on my list, but if you want to defer to the gentleman from Hartford, that's fine with me.
I will. Thank you, Madam Speaker.
Gentleman from Hartford.
Thank you, Madam Speaker. I have a question for the floor leader related to the amendment that the body adopted on the bill this morning.
I believe this is related to the amendment that we addressed earlier this morning, and I think I'd like the gentleman from Montgomery County who is in the back to come out. Emerge. Again, this is related to
Can
that.
the gentleman read the amendment number?
Madam Speaker, I had a couple of questions before reading the amendment. Is that acceptable?
Do you plan to offer the amendment?
Yes, ma'am.
Okay. Well, I'm just trying to save time. Can you get the?
Absolutely, Madam Speaker. I have an amendment at the desk, 723329/1.
Amendment number 1.
So be considered the reading of the amendment.
So ordered.
What this amendment does is we adopt, and I have a couple, actually before I get to that, I'd like to ask the floor leader a couple questions about the bill as amended. Thank you. So with the bill as amended, we unpacked earlier discussing this piece of legislation that anyone can issue a complaint about misconduct in law enforcement. The amendment that we adopted this morning, what does it do related to redacting records of individuals involved in these complaints?
Sure. Thank you.
Leader.
Thank you, Madam Chair. So the amendment we put on in committee make some clarifications to what information will be released. And it specifically says that we are going to redact private medical information of the officer, personal contact information of the officer or witness, and information related to the family of the officer. The amendments further clarify that there is the opportunity to redact the remaining information about the witness, but it is not mandatory. It is a may redact. So the witness contact information will be redacted, but as to the rest, it's discretionary, and I can explain why if you'd like.
No, I appreciate that. And I think most of that amendment's a really good amendment, redacting information and keeping people's information privacy. The piece that alarms me is changing from a shall to a may release the information of a witness. And this is what alarms me about it. There are situations where a witness may witness both the committing of a crime and potential police misconduct. In that scenario, after the individual has been convicted, because there's a provision in here that can't be released during an active investigation, after the investigation is completed, anyone can put forth an information request, and potentially this creates a pathway to get the witness information. And the reason this alarms me is because we've heard in testimony, we've heard in the media, the number of vast concerns about witness intimidation, witness suppression, and frankly, witnesses being murdered on a variety of fronts. We've heard this from State's Attorney Marilyn Mosby. We've heard it from Baltimore Police Commissioner Michael Harrison. We've heard it from everywhere. And this is a real concern. It's a legitimate concern. And it should be alarming to all of us. So what the bill does as amended is allow this information, this witness information, to be accessed by anybody. So say I'm somebody who was convicted of a crime in prison, and I've already been convicted. I can have somebody I know requesting information, get the witness information, and now I can retaliate against the individual. Now there's a provision that can't be done during an active investigation, but the issue is retaliation doesn't end at prosecution or at sentencing. That retaliation goes on until, I've been satisfied to get that revenge. And this is deeply, deeply concerning. So now, what happens in a situation where an individual witnessed not only a crime, but police misconduct, and then that individual is prosecuted, or maybe both individuals are prosecuted, and then through a Public Information Act request, the witness information is released, and that person is murdered. Not only has justice not been done, but think about the chilling effect it will have on anybody wanting to come forward and complain or file a complaint about police misconduct. This amendment, the amendment we adopted this morning, would do the opposite of everything we're trying to accomplish here with police accountability. So my amendment's very simple. All it does is change a may to a shall, saying that the witness information shall be redacted in Freedom of Information Act request to ensure that the witness's right to privacy and the witness's safety and the witness's confidence that if they're making a complaint against law enforcement, that their privacy will be theirs. Thank you, Madam Speaker.
Thank you, Madam Speaker. Colleagues, this amendment is not only unnecessary, it's dangerous. It would put in the dark key facts about police misconduct and what goes on. So first, let me put this a little bit in context and give you a window into existing practice. One of our colleagues on the Judiciary Committee from District 19 is in fact a PIA officer and has indicated to us that these decisions are not made in a vacuum. They actually have a list they have to go through when information is requested. And they're specifically looking to make sure private details, medical information, things that might jeopardize a case or someone's safety. In fact, these are already in existing law in the Public Information Act. The PIA officers are supposed to deny requests that deal with current law enforcement proceedings, information that would deprive another person of a right to a fair trial, unwarranted invasion of personal privacy, things that would disclose investigative techniques or procedures, things that would endanger the life or physical safety of an individual. And let me tell you, in the day, when I have time, I've been trying to catch what's going on in the Derek Chauvin trial, and you could see interesting glimpse as to the public policy discussion being implicated there, and it's coming by way of witnesses. And so look at the list of witnesses that was produced in that trial. We have bystanders. Some of them had video footage. That ended up being useful. We have bystander statements. Well, that's also useful information. Again, this is all information that could come out without jeopardizing the safety of those particular individuals. You had EMS and paramedics. You had a 9-year-old, and they actually did shield the 9-year-old's identity for their safety, but made known that there was a 9-year-old witness. You had the cashier at the store who made the call because of counterfeit bills. You had the police trainer. These were all witnesses, and your proposal would mandate that we take all of this information out. No, thank you.
Madam Speaker.
Maker of the amendment.
But that wouldn't apply to what we're discussing here because that's still an active investigation and active situation. This is referring to a variety of complaints that of a completed investigation where somebody was convicted or not convicted, or any complaint of substantiated or unsubstantiated. So the question is this: if an individual makes a complaint against law enforcement and they know there's a possibility that their information could be released to the public for making that complaint, why would they put themselves out there like that? Why would they do that? Especially in a situation where you're at intersecting complaints, right? A situation where there's a witness of police misconduct or a complaint of police misconduct intersecting with someone who's committed a crime. There's a difference from individuals coming forward to the media and wanting to make their story public voluntarily and it being thrust upon them by this body. There's a huge difference between that. And all those witnesses you're talking about were encapsulated in the investigation anyway. So we're talking about two different things here. This is people who made a complaint that now, against their will have their information made public. Who would want to make a complaint with this hanging over them? I certainly wouldn't. And that's why I'll be voting for this amendment. Thank you, Madam Speaker.
On the amendment, all in favor signify by saying aye. Opposed?
Roll call.
Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails. Are there any additional amendments to the bill to its title? Gentlemen, are you now going to offer amendments?
Thank you, Madam Speaker. Madam Speaker, I have an amendment at the desk, Amendment 893921.
Amendment number 1.
Thank you, Madam Speaker. Ladies and gentlemen.
Move so much in reading of the...
Move so much be considered the reading of the amendment. Thank you, Madam Speaker.
So ordered.
This amendment is a straightforward bipartisan attempt to find middle ground to ensure transparency while at the same time protecting our law enforcement officers, protecting their families, protecting their children from improper public exposure and smearing on the internet. Now, you heard that the unsubstantiated and unsustained, unfounded complaints will be released now, sadly, under this bill. And you also heard that there will be witness information, unredacted, put out there, even if the witness doesn't want that released. That's a travesty under this bill, but this amendment is straightforward and simple to tighten that and provide guardrails. All it says is this: a record under this subsection is a personnel record for the purposes of the subsection if the record relates to a complaint, unless the complaint was made under penalty of perjury. So right now, ladies and gentlemen, what's going on, or what will happen under this new approach, this reimagining, is that now an unsworn complaint can be filed against a law enforcement officer and then found to be false and completely unfounded, and it will still be released. And this amendment, ladies and gentlemen, simply says this: if it's going to be released, it needs to be under penalty of perjury. And why is that important? Because that will tighten the ship. That will ensure that all of these complaints that are being made, many of which are made straight out of prison, some of them completely, many of them, as we heard, over 70%, false, unfounded, that this will allow that when a complaint is released under a Public Information Act request, we're not talking about investigations, the Attorney General will still have access, the state's attorney will still have access, the investigation will still have access, the persons of interest will still have access. What we're talking about is a Public Information Act request. They need to only be complaints that are under penalty of perjury, which can be proven up, verified whether true or false, so that the officer and his family is protected. With that, I would move the amendment.
Madam Speaker.
Gentlelady from Baltimore City.
Thank you, Madam Speaker. I'm going to urge the body to resist this amendment. We passed earlier this year, unanimously in this chamber and unanimously across the hall, a bill, HB 183, that also deals in a comprehensive way with our Public Information Act. And that bill not only declares that it is the policy of the state that we provide proactive disclosure whenever possible, but it sets up a way so that when there is a Public Information Act request made that is not in good faith, that is frivolous, or that is vexatious, the Public Information Act Compliance Board can say so, and can say that it will uphold the agency's decision to withhold that record. And we did that because we want to make sure that those record requests, those PIA requests that are out there that are made in good faith, are being handled expeditiously and thoroughly. And so this amendment is contrary to the intent of this bill. It's contrary to the intent of legislation that we have already passed unanimously, and it's not needed. So I urge the body to resist this amendment.
Maker of the amendment.
Thank you, Madam Speaker. And I thank the gentlelady, but I would like to point out two things. First of all, vexatious is a very high standard, and most fact finders are not going to be making repeated vexatious denials under this law if passed. And the reason for that is because you have to take things as true on their face. So unless you have further information and it clearly is just simply absolutely false on its face, which is going to be a very small percentage of these filed complaints, then it will be released to the public and it will have information in it that it's false. The importance of this is that the current structure of the bill, at least as the last that I've seen it, is that there are two options. So this is an opt-in. Individuals will still be able to file complaints without having to make a penalty of perjury affirmation. But what this does is it says, but if you are going to make these kinds of allegations such that they are going to be released on the internet, then you need to put your name to it under oath to make sure that there's veracity and protection to the officers and their families and their children. And with that, thank you. I'd move the amendment.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
clerk will take the call. The amendment fails. The gentleman from Frederick.
Thank you, Madam Speaker. I have an additional amendment at the desk, Amendment 173228.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. Ladies and gentlemen, it is important in our system of justice that we ensure that information that shouldn't be out in the public and spread all over the internet is in fact protected. Recently in Baltimore City, just this month, or this past month actually, in March, there was an information posted to an Instagram account of a video of a mom, a mother who did this. Her son was in jail. And she posted the video of witness information. This is a very concerning situation because what happened was then she called in and the discussion was such, she said, all rats must go. Thankfully, the information was not to be released on Instagram, and so she was arrested. But this bill will potentially open a loophole to allow this kind of information to now be publicly released lawfully, and that's not appropriate for our system of justice, nor is it appropriate for our witnesses, as we heard earlier about the concern for the witnesses' protection. This amendment, Madam Speaker, simply says this: a person who is provided the records described under the subsection shall sign a statement that they will not release the record to a third party under penalty of perjury. In addition, if they do, they will face a misdemeanor crime. With that, I'd move the amendment.
Recognizing the committee chair.
Thank you, Madam Speaker. The delegate who serves on the Judiciary Committee is well aware of this amendment because he offered it in committee. It was defeated in committee. And for all of those reasons, it should be defeated here again today. Please vote against the amendment.
On the amendment, all in favor signify by saying aye. Oppose? No.
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
Clerk will take the call. Amendment fails. Gentleman from St. Mary's.
Thank you, Madam Speaker. I have an amendment at the desk. Amendment 893125/1.
Amendment number 1.
So I saw this bill was hitting the floor last night, and I was thinking back of some of the conversations that have been held over police reform and police accountability over the last couple years. And I thought back to last June when I met with my local NAACP chapter in St. Mary's. And the meeting was with them and our local sheriff. And we started going over some statistics of St. Mary's County. And the year previous, 2019, we had 143 officers run 75,000 calls in the county. And it turns out there was only 44 total complaints out of the 75,000 calls. And the surprising thing was 29 of those complaints came from other officers against other officers. So let's think about that. They're policing themselves. Out of 75,000 calls, only 15 came from the general public, and each one of those calls were investigated. We started looking at it, and we found that we have a lot of those similar outcomes in some of the rural areas of Maryland. And we started, why? Why are some departments just seemingly ran better than others? And it seems like there is a major difference that I don't know a lot of people know about between a sheriff and a police chief. A sheriff is locally elected, represents the constituents that elected him. He's directly accountable. A police chief works for the pleasure of the mayor or the executive. So when you have situations like we had in the Baltimore riots, when you had the mayor of Baltimore, the former mayor of Baltimore, Stephanie Rollins Blake, say, give them room to destroy. She's making a political decision with your livelihood, your property, and maybe your life. She's making a decision based on the advocates and the activists that I'm not sure a sheriff that was locally elected and accountable to the voters would make that same decision. So what this amendment does is take the top law officer in each county, where it's a chief or a sheriff, and make them locally elected. We need to get the politicians out of policing. This whole bill, there's not many, politicians and policing shouldn't go hand in hand. So this is what this amendment does. It's make it locally elected. With that, Madam Speaker, I move the amendment.
Chairman of the committee.
Oh my, Madam Speaker. So we need to get the politicians out of policing, and that's why we need to elect all of the lead law enforcement officers across the state so they can go out and raise money. Wow. Well, I don't know. I'd say this was half-baked, but that would be rude. Please, I ask you to vote red on the amendment.
Madam Speaker,
Recognizing the minority leader.
I would love to talk all day about John Leopold and his situation with corruption. And fortunately, he's no longer in office. But in situations like that, I don't think that you'd want, when you have a corrupt executive, I don't think you'd want to have that individual in a position to hire or fire the police chief. And since that day, I've always been in favor of having an elected police chief. Thank you.
Madam Speaker.
Recognizing the gentleman from Calvert.
Thank you, Madam Speaker. I couldn't help but think of in 2020, and even currently for that matter, in Seattle and many cities across the country, how the mayors looked the other way when statues were being torn down, including Baltimore City, where they tore down a statue of Columbus, as well as in Seattle, where they had it was called Chaz, and then they changed it to CHOP, an autonomous zone in Seattle. And the idea was, of course, they were going to create their own, city within a city. And then they ended up having people raped. They had a murder. They had 2 people shot. This is from a New York Times article in June of 2020. And what happened? The police chief looked the other way because the police chief was serving at the pleasure of the mayor. If a police chief is serving at the pleasure of the citizens would never, ever put up with it. And that police chief would most definitely have listened to the citizens and would be hearing them. And I have no doubt in Seattle and in many other cities across the country, the police chiefs were hearing from the citizens, but were being ordered to do the opposite of what made sense. In my own county, in Calvert County, a pretty extraordinary thing happened last year, and that is we had Antifa activists from outside of the county. And we had BLM activists outside the county, and they came to Prince Frederick, my hometown. They weren't from the county, and they were initially peacefully protesting, which is a great thing, a good thing. It quickly, within an hour and a half, turned into something very different. Had I not seen this with my own eyes, Madam Speaker, I would never have believed what I heard and saw. In fact, my aide here in Annapolis was working for a paper and recorded the entire thing on behalf of the paper on Facebook Live, so it is there for posterity, thank God. The words that they were calling these police officers in their face, standing 2, maybe 1 foot away from the police officers, really that close, yelling in their faces, calling them every name in the book, so incredibly inappropriate. And the professionalism of the Calvert County Police Office, of the police officers and the sheriff was stellar. Later, I asked the sheriff in Calvert County, who's elected, I said, how do you think you handle that? And he goes, well, I know that we handled it well, and I said, I agree, you guys did such a great job. It was so professional. I said, what makes it different here than in the cities across America that we're seeing? Because this was in 2020. And he said, you know what, delegate? The difference is I work for the people. My job is to keep them safe. This is one of the best amendments I've seen on the floor about this police accountability issue, because we keep police officers accountable by electing a sheriff to run the department. It makes perfect sense to me. So some may certainly make fun of that and say, oh, gee, we're going to make them into politicians. Really? You don't think the officer that runs, the highest police officer in Seattle, isn't a politician by letting buildings burn and occupy part of the city? It's a great amendment. I support it for all those reasons. Thank you, Madam Speaker.
All in favor signify by saying aye. Opposed? No.
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. Are there any additional amendments to the bill to its title? Hearing none. Oh, no. Senate Bill 178 is on third reading and final passage. Clerk will call. Oh, sorry. Okay. The gentleman from Montgomery County and the Annex.
Thank you, Madam Speaker. I just have a quick clarifying question, if the floor leader would be able to answer that.
Committee Chair.
Good afternoon.
Good afternoon. I just want to make sure, I know there was some amendments that were adopted that it would allow for redaction as opposed to denial in terms of information requested.
I'm sorry, ask the question again, please.
It would allow for redactions as opposed to denial.
Correct. The amendment, the committee's amendment, deals with redactions of specific parts of records.
Okay, good. The other thing is I wanted to ensure that that in investigations we're also not on the list of mandated redactions.
I'm sorry, I have to ask you to ask that question again.
So I believe in the previous language I was looking at, I know investigations, let me make sure I have the exact language here.
That if there is a current investigation?
Let me see the language. Yes, so active investigations. From the previous language, I know active investigations were on the list, but I just wanted to make sure that we removed active investigations from the list in terms of mandated redactions.
Active investigations, that's existing law that the custodian can deny access to those files.
Okay. Thank you. Thank you, Madam Speaker.
The gentleman from Anne Arundel in the Annex. After they wipe it down.
Thank you, Madam Speaker. I apologize for earlier going over and explaining my vote, but today I call upon my colleagues to vote against this bill, Senate Bill 178. We are here to establish policy. policy that moves our state forward. And I agree, we must make sure that bad actors, bad law enforcement officers, don't continue in the field. However, this legislation and many of the other pieces of legislation that we are considering overall are not going to be good policy. They're not going to be good policy because it's going to encourage people to leave the field of law enforcement and to decide not to go into the field of law enforcement. Particular parts of 178 that are going to cause individuals who are looking for a career they can be proud of, is going to be the fact that now individuals can make accusations against them, maybe to put them in a better position to continue to commit crimes that are not made under oath, can be exposed and distributed throughout the public. Those things are going to be available for individuals to acquire for improper means. Furthermore, earlier I asked everyone to wait and see what 20 seconds look like. We're going to ask law enforcement to basically knock on a door, wait 20 seconds, and put their lives in jeopardy when they do their correct duty to serve a warrant. There's other problems with the warrant, including the fact that the warrants become stale at 10 days. That basically means that law enforcement may need to execute a warrant, which is not the best time. It should be longer than that. It should be at least 14 or 15 days. Also, requiring the limited hours of 8 to 7 o'clock, once again, is not the best policy. We're asking for it to be done almost like banker's hours, putting our law enforcement in front, in jeopardy, and also enabling the criminals to be able to time when they conduct their crime and time when they can be protected from being caught and committing the crimes. For these reasons, I ask for this body to oppose this legislation, to oppose Senate Bill 178, and that because we can do better for all of Maryland, for our law enforcement, and most importantly for our citizens. Thank you, Madam Speaker, and please join me in a red vote.
Any further debate? Clerk will take the call.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 88 votes in the affirmative, Senate Bill 178, having received a constitutional majority, is declared passed. House Bill amended in the Senate. House Bill 135, the clerk will read the bill and the Senate amendments.
House Bill 135, Pharmacists, Administration of Self-Administered Medications and Maintenance Injectable Medication, Crystal King Access to Treatment Act, Amendment number 1.
Thank you, Madam Speaker. HGO moves to not concur with the amendment.
The motion for the House is to not concur in the Senate amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. Amendments are rejected. Clerk will read the message to the Senate.
Ladies and gentlemen of the Senate, the House of Delegates refused to concur in the Senate amendments and respectfully request the Senate recede from its position. Should the Senate prefer a conference committee to confer the disagreeing votes of the two houses, the House appoints Delegate Kelly chair, Delegate Cullison, and Delegate Kipke. Said bill is returned herewith.
Report of the Committee on Rules and Executive Nominations, consent calendar number 58. Clerk will read the first bill. Report number, 58. Report number 6.
House Bill 1358, re-referred to Health and Government Operations.
Recognizing the Majority Leader.
Thank you, Madam Speaker. I move that the reading of House Bill 1358 be considered the reading of all the bills on the calendar.
So ordered. All the bills are re-referred to the appropriate committees. Report of the Committee on Health and Government Operations, report number 24. Clerk will read the first bill.
House Bill 1030, State Board of Dental Examiners, Membership, Nomination, and Appointment Process, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
Senate Bill 132, Inspection of Public Records, Notaries Public, Disclosure of Home Address and Phone Number, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered printed for past the third reading. Clerk will read next bill.
Senate Bill 139, Interstate Occupational Therapy Licensure Compact, favorable.
Question for the House is adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 284, Maryland Veterans Service Animal Program, definitions, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 652, Public Health Long-Term Care Planning, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill as to its title? Hearing none, the bill is ordered to pass the third reading. Report of the Committee on Health and Government Operations, report number 25. Clerk will read the first bill.
House Bill 108, Behavioral Health Crisis Response Services, modifications, favorable amendments, amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 makes technical changes. Amendment number 2 strikes language that would have required the Health Department to require the proposals for crisis response grants contain response standards that minimize law enforcement interaction and level the funding program at $5 million a year for fiscal years 2023, 2024, and 2025. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment is adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill as to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 652, Health Facilities, Residential Service Agencies, Guidance and Reporting, favorable amendments, amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 clarifies the certification is required as a condition of the initial license and every 3 years thereafter. Requires the certification be completed on a form developed by MDH that includes a checkbox by which the RSA that receives reimbursement from Medicaid will indicate whether the RSA uses personal care aides designated as independent contractors, strikes language requiring an RSA to report to MDH whether it classifies personal care aides as an employee or a contractor, and the hourly pay rate of personal care aides. Requires Maryland Department of Labor to submit a report on strategies the Labor Commissioner has taken to educate RSAs and workers on laws governing classification of independent contractors. Requires MDH to submit a report on steps taken to bring rates for personal care aides in line with the cost of delivering services and turnover of personal care aides, and changes the effective date. Move the amendments.
Question for the House is adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. Amendments have been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
Senate Bill 84, Pharmacists, Administration of Self-Administered Medications and Maintenance Injectable Medications. Favorable amendments. Amendment number 1.
Recognizing floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 makes the bill an emergency, changes the title, and makes other technical changes. Amendment number 2 strikes language that would have included medications that treat a sexually transmitted infection in the definition of maintenance injectable medication, strikes specified notice provisions, and instead requires the regulations established by the board include procedures for notifying the patient about payment for services, and makes additional stylistic changes to conform to the cross-file as it passed the House. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendments have been adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk, read next bill.
Senate Bill 286, Behavioral Health Crisis Response Services Modifications. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Move so must be considered the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 strikes certain standards that would have minimized law enforcement interactions, and levels funding for the program at $5 million a year each year in fiscal years 2023, 2024, and 2025. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendments are adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk, read next bill.
Senate Bill 379, Health Occupations Licensing of Audiology Assistants. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
Amendment number 1 is technical. Move the amendment.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment has been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk, read next bill.
Senate Bill 384, Health Facilities, Residential Service Agencies, Guidance and Reporting. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
The amendments conform the bill to the version that just passed second reader in the House a minute ago. Move the amendments.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment is adopted. Question now is adoption of favorable report as amended. All in favor signify by saying aye. Opposed, no. The favorable report is adopted. Recognizing the gentleman from Talbot in the annex.
Thank you, Madam Speaker. Could the floor leader rise for a question or two on this bill?
Yes, sir.
All right, so I missed the other bill over here in the annex. Sometimes hitting that button timely is not easy. Could you walk me through the part of the bill that relates to independent contractors? That was sort of a key word for me, but just kind of walk me through this bill a little bit.
Sure, Delegate. So I understand that's a key word for a lot of folks, so I just want to make sure it's clear to you that we amended this bill as it came in. So originally the bill was introduced, and this is similar to a bill that has been heard in previous years in other committees related to residential service agencies. Those are home health care providers. The bill is introduced, had some reporting related to independent contractors, and we struck the reporting with these amendments. So now, as it stands, it's just going to be a guidance document that was agreed to by all of the stakeholders, and the guidance document is going to be produced by the Attorney General's office and shared with the residential service agencies. They're going to have to sign the guidance document, and we're also going to get some reports to the relevant committees on the current practices with the Department of Labor, and we're going to have reports from MDH on what we can do to raise rates in general for these providers.
So I guess my question was a little bit differently. So in this industry, you have independent contractors that are providing services. What is the role of the Department of Labor now that the bill's been amended? So I'm trying to understand, if I'm an independent contractor now in this industry, how does this bill change my relationship with my customers?
Thank you for asking that question. So we're obviously interested as a state in terms of our Medicaid-funded providers. So the only difference in this bill is that there's a checkbox on the guidance document for Medicaid-funded providers to check off if they use independent contractors. There's no reporting of wages or hourly rates. And there is, the guidance document that's going to be developed by the Attorney General's office just to clarify existing law. There's no enforcement, increased enforcement or anything like that in this bill.
So I'm reading the fiscal note, and there's reference to the ABC test, which I'm very familiar with. Is there any discussion about misclassification? Honestly, I wish I would have held the House bill. Let me just be blunt. Would you be willing to hold the Senate bill since I missed the House bill so I can look at this for amendment? I know it's not normally provided, but it would be helpful for me in a second reader format to ask some additional questions by way of
Senate
amendment.
bill can be amended on third reading.
I know that. Thank you, Madam Speaker. So I guess I'm back to the question on misclassification. Is this bill asking the Attorney General, for example, to come up with guidance as to whether or not a independent contractor is or is not a contractor in this respect?
No, this bill, it does not particularly get into anything other than what is the existing law. We're not developing new guidance. We're just sharing a guidance document based on the existing rules that the RSAs would then be reading and acknowledging that they've read. So again, it's very different bill from the bill that was heard in the Economic Matters Committee last year.
All right. Well, thank you to the floor leader. And Madam Speaker, I can't wait until I get back on the House floor so I can jump up and ask some questions. It's tough over here.
All right. Hopefully next year, next session, next time. All right. Are there any additional comments, amendments to the bill to its title? Hearing none, the bill is ordered, passed to third reading. Clerk, read next bill.
Senate Bill 507, Division of Consumer Protection Assisted Living Programs. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Move so much be considered the reading of the amendments.
So ordered.
The amendment is clarifying. Move the amendment.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment is adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered, passed to third reading. Clerk will read next bill.
Senate Bill 745, Health Occupation State Board of Massage Therapy Examiners. Revisions. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Move so much be considered the reading of the amendments.
So ordered.
The amendment, I'm sorry I don't have it in front of me, but I can tell you what it does. It clarifies and restores existing law from the previous bill it clarifies law. It basically, it takes out something we struck originally. We didn't mean to strike it. And that is language that clarifies that insurance providers don't need to cover these services. Move the amendment.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment has been adopted. Question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered, passed to third reading. Clerk will read next bill.
Senate Bill 857, Health Maryland Behavioral Health and Public Safety Center of Excellence Establishment. Favorable amendments. Amendment number 1.
Recognizing floor leader.
Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 clarifies that certain screening processes must be properly applied, and that the centers shall continuously monitor the validity of their plans and policies. As amended, this bill is identical to its cross-file House Bill 1280, which passed the House unanimously. Madam Speaker, move the amendment.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment is adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered passed to third reading. Message from the Senate. Senate bills introduced in the House. The clerk will read the bills and committee assignments.
Senate Bill 334, Senator Carter, House Rules. Senate Bill 460, Senator Feldman, House Rules. Senate Bill 577, Senator McRae, House Rules. Will Order Sylvia Seeger, Chief Clerk.
Yea and nay. Consent calendar 7. House bills passed in the Senate. The clerk will read the first bill.
House Bill 115, Delegate Moon.
Majority Leader.
Thank you, Madam Speaker. I move that the reading of Senate of House Bill 115 be considered the reading of all the bills on the calendar.
So ordered. Message from the Senate. House Bill 670. The clerk will read the bill.
House Bill 670, Police Reform and Accountability Act of 2021.
The clerk will read the message from the Senate.
Ladies and gentlemen of the House of Delegates, the Senate does not recede in the Senate amendments and agrees to a conference committee to confer on the disagreeing votes of the two houses. The House has appointed Delegate Clippinger chair, Delegate Atterbury, and Delegate Moon. In addition, the House has appointed in advisory capacity Delegate Kipke. The Senate appoints Senator Smith chair, Senator Carter, and Senator Jackson. In addition, the Senate has appointed in advisory capacity Senator Huff. Said bill is returned.
Report of the Committee on Economic Matters, report number 44. Recognizing the clerk will read the first bill.
Senate Bill 103, Business Regulation, Retail Pet Stores Modifications, No More Puppy and Kitten Mills Act of 2021. Favor of the amendments. Amendment number 1.
Recognizing the Vice Chair of the Committee.
Thank you, Madam Speaker.
Pick up your mic. Can you pick up your mic and tell what be?
Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 strikes a definitional change and establishes a task force. Move the amendments.
Question for the House is the is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. Amendment has been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill to its title, recognizing the gentlelady from Baltimore County?
Thank you, Madam Speaker. So we all love puppies and kittens. What can you tell us about this bill, please?
The bill basically provides that in the state of Maryland, you can purchase a puppy directly from a breeder, or if you do it through a pet store, the pet store can work in cooperation with the shelter or a rescue.
And it looked like when I read it, and I think I'm reading the reprint, that it struck out some language from last year. Is that right? At the end of the bill?
It did strike out some language from last year that talked about offer of sale. That led some pet stores to believe that they could be opened by appointment. And so the purpose of this is to make it clear that the only way to purchase puppies or kittens in Maryland is through a breeder directly or through a pet store, but they can only do that through working with the animal shelter or rescue.
So are we going to not have any more pet stores? Is that?
Pet stores can sell other things, supplies. There are other animals that they are able to sell, but this is an effort to, as the title says, make sure that Maryland consumers are not purchasing animals from puppy mills.
Right, sure. There's a big difference between a puppy mill and a pet store. I understand that. And this is just formulating a task force?
formulates a task force because what we have found is it is a very complicated area of law. We want to be sure that we take the time to study it.
Oh, that's good. Okay, thank you.
Thank you.
Is there any further debate? Hearing none, the bill is ordered past the third reading. Report of the Committee on Health and Government Operations. Report number 26. Clerk will read the bill.
House Bill 132, Health, Mental, and Emotional Disorders, Consent, Mental Health Access Initiative, favorable.
If the floor leader would rise, we'd like to request a special order into the appropriate time next session.
Recognizing the committee chair.
That's fine, Madam Speaker.
Question,
Thank you.
Question for the House, a special order HB 132 to appropriate time next session. All in favor signify by saying aye. Opposed, no. The ayes have it. The bill has been special ordered. Report of the Committee on Environment and Transportation. Report number 38. Clerk will read the first bill.
Senate Bill 77, Energy Efficiency Net Zero Homes, Contract Preferences, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Question now, are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 159, Local Government, Humane Society, and Animal Control Officers, Education and Training Requirements, favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Senate Bill 159 requires a new officer of a Humane Society or Animal Control to satisfactorily complete training for animal care and control professionals. And the amendments are technical and clarifying. Move the amendments.
The question before the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 324, Environment and Natural Resources, Complaints, Inspections, and Enforcement, Information, Maintenance, and Reporting, favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Be so much consider the reading of the amendment.
So ordered.
Thank you, Madam Speaker. As amended, the bill is identical to HB 204 passed by the Senate. Committee amendments conform the bill to HB 204. Amendment number 1 makes technical changes. Amendment number 2 requires MDE to post information on sewage overflow incidents. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendments have been adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 338, Local Government Animal Control Facilities, Adoption Fee Waiver for Veterans, Pets for Vets Act of 2021, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 687, State and Local Housing Programs, Affirmatively Furthering Fair Housing, favorable amendments. Amendment number 1.
Madam Speaker.
Recognizing floor leader.
Move so much for your reading of the amendment.
So ordered.
As amended, the bill requires DHCD to administer its programs and activities to affirmative further fair housing. It is further establishing local jurisdictions to have a duty to affirm further fair housing and requires them to submit assessment for fair housing as a component for the housing element for local jurisdictions. The amendments, Madam Speaker, conform the bill to House Bill 90 that was previously passed in the House. Move the amendments, Madam Speaker.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendments have been adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Recognizing the gentlelady from Carroll County.
Thank you. Yes, you said you amended the Senate bill to the House bill.
Yes, that's correct.
So did it solve the problems that I guess you didn't solve the problems we had on the House bill. CCHD did not support it, and did MACO have any position on this?
Let me check about MACO.
Mr. Subcommittee Chair?
Oh.
Thank you.
I yield to the sponsor of the House bill.
Thank you, Mr. Chair. Yeah, MACO, we worked extensively with MACO and MML on HB 90 when it came through. And so with the amendments that we made, they do not oppose the bill anymore.
Did they support the bill?
They were neutral.
And what about the CCHD?
What is CC? Sorry, I don't know what CC.
Oh, that was the Carroll County Health Department. I mean, the health departments. They weren't supportive.
We did not hear from the health. We did not
Any of the
engage
health
or talk
officers
with
you
the
didn't
health
hear
officers. No.
So who was opposed to the bill as it was amended in the House?
As amended in the House, I was not aware that anybody was opposed to the bill. It simply adds the affirmatively furthering fair housing to the housing element that has to be done as part of a comprehensive plan every 10 years. And then it provides for an update every 5 years on the efforts that our jurisdictions are making to meet that housing element.
So all of the opposition testimony, all of them are now supportive of the bill.
I can't promise that they're supportive, but they don't have a position that I heard from after we amended it.
Thank you.
Is there any additional comments? Hearing none, the bill is ordered past the third reading. Conference Committee report, House Bill 517. The clerk will read the bill and the Conference Committee report.
House Bill 517, Clean Energy Loan Program, Remediation and Resiliency, Amendment Number 1.
The Chair of the Conference Committee. HB 517.
Move the Conference Committee report.
The motion before the House is to adopt the Conference Committee report. All in favor signify by saying aye. Opposed, no. The ayes have it. The Conference Committee report is adopted. House Bill 517 is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 106 votes in the affirmative, House Bill 517, having received a constitutional majority, is declared passed. Concurrence calendar number 11. The clerk will read the bill and the Senate amendments.
House Bill 540, Interstate Occupational Therapy Licensure Compact, Amendment Number 1.
Recognizing the committee chair.
Thank you, Madam Speaker. We move to concur.
The question before the House is to concur in the Senate amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. House Bill 540 is on third reading and final passage. The clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, House Bill 540, having received a constitutional majority, is declared passed. Clerk will read the next bill.
House Bill 599, Public Health Long-Term Care Planning, Amendment Number 1.
Recognizing the committee chair.
Thank you, Madam Speaker. Move to concur.
Question for the House is concur in the Senate amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. House Bill 599 is on third reading and final passage. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, House Bill 599, having received a constitutional majority, is declared passed. Clerk, read next bill.
House Bill 849, Public Health Medical Records Fees, Amendment number 1.
Recognizing the committee chair.
Thank you, Madam Speaker. We move to concur.
Question for the House is to concur in the Senate amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. House Bill 849 is on third reading and final passage. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, House Bill 849, having received a constitutional majority, is declared passed. Clerk, read next bill.
House Bill 871, Consolidation of the Procurement Improvement Council and the Council for the Procurement of Health, Educational, and Social Services, Amendment number 1.
Recognizing the committee chair.
Thank you, Madam Speaker. Move to concur.
Question for the House is to concur in the Senate amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. House Bill 871 is on third reading and final passage. The clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, House Bill 871, having received a constitutional majority, is declared passed. Clerk, read next bill.
House Bill 989, Public Safety 911 Emergency Telephone System Alterations, Amendment number 1.
Recognizing the committee chair.
Thank you, Madam Speaker. Move to concur.
Question for the House is to concur in the Senate amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. House Bill 989 is on third reading and final passage. The clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 135 votes in the affirmative, House Bill 989, having received the constitutional majority, is declared passed. Quorum call.
Madam Speaker.
Calendar of third reading Senate bills number 39. Oh, take the call. Sorry. There are 135 members present. The House is still in session. The calendar of third reading Senate bills number 39. The clerk will read the first bill.
Senate Bill 19, Economic Development Biotechnology Investment Incentive Tax Credit Program Alterations.
Is on third reading and final passage. Is there any debate?
Madam
Recognizing gentlelady from Carroll.
Thank you. Can someone explain what's been changed for these biotax credits?
Recognizing Majority Leader.
Thank you, Madam Speaker. Yes, so this and the ensuing bills are actually a result of conversations that the committee's been having with Commerce for the last year, trying to tighten up some of the requirements in various tax credit programs. This bill in particular, as introduced because the program has been oversubscribed, reduces the value of the credit so that it can be sort of spread more evenly among the recipients. Establishes goals for the program, sets a clear 12-year limit for the participation of a QMBC in the program, that's the business, and then also sets limits on the percentage of the credit that can go to an individual company in any given year and the amount of credit that a company can receive over a lifetime. And those things are intended to help small businesses to gain, and newer businesses to gain access to the credit. And then the committee added some amendments, which we adopted on second reading yesterday. Those included adding this to the now almost all of our business tax credits have sunset dates to force us to do periodic review, and also added an amendment that says after the first 5 years, founders and current employees of the company can't benefit from the investment credit because the credit's intended to incent outside investment. We don't want to just reward people who already have a financial incentive to invest.
So does this encourage new people to get tax credits or not, or expand the breadth?
I think the combined weight of all of these reforms will make this program much more effective at achieving the state's goals.
One of the concerns, I believe, of this program, if I got it correct, is that it's sort of first come, first serve when people get in. So people that know how to get the credits and know how to get their requests in, they get it first. So how do we encourage or even look at the scope and the value of what they're bidding for?
It's a really good question. It's something the committee's been struggling with the last couple of years, as has the department. The challenge here is who picks, right? If you're going to decide that businesses get the credit, you have to decide on a set of criteria and you have to determine who makes that decision. What we did in this bill is we required Commerce to engage in a study on this bill and the what used to be the cyber investment tax credit, that's now the innovation investment tax credit, to come back to us with recommendations about a potential system that's an alternative to first come, first serve.
So is there any review of somebody that's going for a credit that's already gotten a credit to see if they produced the value that they said they were, whether it's jobs or a product? Is there any a review of these tax credits ever to see how they've done?
Yes, we have extensive evaluations of these credits done both by the Department of Commerce and by DLS. In fact, many of these reforms are based on previous DLS analyses. We've taken their recommendations and sort of adopted them into these bills.
It sounds like there's a lot of good things in this bill. The only thing that I have a problem with is that it's first come, first serve. That's really not a very deliberate way of deciding who gets a tax credit. It really should be based on their past experience and what if they've delivered what they promised when they said they were going to when they got the tax credit.
Yeah, I agree with you. I mean, as I said, I think so we added the reporting language by amendment into this bill. It's something the committee is going to continue to work on and try to figure out. That first come, first serve is existing in the credit, so we're not changing it yet here. But I think our long-term goal is to find a more efficient way for it to be delivered.
And what's the date of the report? When's the date of the report for this review?
By next session.
By next session. That's good. Thank you.
Is there any further? Gentleman from Cowell.
Thank you, Madam Speaker. Just have a quick question for the floor leader. On page 2, it says qualified investor means any individual or entity that invests at least $25,000 in a qualified Maryland biotechnology company and that is required to file an income tax return in any jurisdiction. Does that mean they can live outside the state?
Can you point me to which line on page 2 you're talking about?
Sure. Looking at the reprint, so it starts with line 5, and then if you look under that, you'll see it.
Yes. So the goal of this credit is to drive investment. So if your question is, could the investor receiving the credit be someone from out of state? The answer is yes. The company has to be in Maryland.
Got it.
So the goal of the credit is to drive that investment.
Thank you.
Is there any further debate? If not, the clerk will take the call.
Madam Speaker?
Call the roll, rather. Has everyone recorded their vote? Does anyone care to change your vote? If not, the clerk will take the call. There being 97 votes in the affirmative, Senate Bill 19, having received a constitutional majority, is declared passed. Clerk will read next bill.
Senate Bill 80, Economic Development, Maryland Technology Development Corporation, alterations.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 135 votes in the affirmative, Senate Bill 80, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 160, Economic Development, Cybersecurity Investment Incentive Tax Credit Program, expansion and extension.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 99 votes in the affirmative, Senate Bill 160, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 196, Economic Development, Research and Development Tax Credit, alterations.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, clerk will take the call. There being 135 votes in the affirmative, Senate Bill 196, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 283, Student and Military Voter Empowerment Act.
It's on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, clerk will take the call. There being 107 votes in the affirmative, Senate Bill 283, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 607, Criminal Law, Harm to Service Animals.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, Senate Bill 607, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 919, Horse Racing Fair Hill Natural Resources Management Area.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 132 votes in the affirmative, Senate Bill 919, having received a constitutional majority, is declared passed. Calendar of third reading, Senate Bills number 40. Clerk will read the first bill.
Senate Bill 17, Criminal Law, Life-Threatening Injury Involving a Motor Vehicle or Vessel, Criminal Negligence, Wade's Law.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 133 votes in the affirmative, Senate Bill 17, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 22, On-Site Sewage Disposal Systems Inspection Licensing.
Madam Speaker.
Recognizing the gentlelady from Baltimore County.
Thank you, Madam Speaker. Would it be possible to special order this bill? To the floor leader?
Yes, it would. Until when?
Whenever works for you. How about next time?
Until tomorrow. I'd accept a special order until
the next session.
The appropriate time in the next session.
Okay. Thank you very much, Madam Speaker.
Question before the House is a special order, Senate Bill 22, the appropriate time next session. All in favor signify by saying aye. Opposed, no. The ayes have it. The bill has been special ordered. Clerk will read the next bill.
Senate Bill 43, Criminal Law, Law Enforcement Officers, Prohibition on Sexual Activity.
It's on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 95 votes in the affirmative, Senate Bill 43, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 105, Peace Orders, Workplace Violence.
It's on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 136 votes in the affirmative, Senate Bill 105, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 227, Water Pollution, Stormwater Management Regulations, and Watershed Implementation Plans, Review and Update.
It's on third reading and final passage. Is there any debate? The minority whip.
Thank you, Madam Speaker. Floor leader on this, please.
Go ahead.
Yes, Delegate.
Thank you. Can you tell us where the Farm Bureau is on this bill?
The Farm Bureau? don't have my full report with me. I can let you know.
Great, thank you.
Sifting through paper. Nothing came from the Farm Bureau.
They didn't weigh in on this either way?
No,
Okay, was there opposition to this?
I don't have this with me. The amendments eliminated opposition.
Okay, so everybody, what,
It's good.
what did you do in the end to make everybody happy? Good one.
The stakeholder work group was established, and a couple of additional stakeholder was added. That was the main.
Okay, so the people that were opposed, you put on the stakeholder work group, and so they feel like they're going to be represented?
Yes, delegate.
Okay, thank you.
You're welcome.
And what was the vote in committee?
It's not in that book. You have to ask. I'm sorry, I don't have the file. Thanks.
19-4?
Yep.
Okay, thank you.
Gentleman from Calvert.
Thank you, Madam Speaker. I also had a simple question. It says, at least in the fiscal note, I'm not sure if this still applies, requires MDE to submit a climate load allocation addendum to the Chesapeake Bay total maximum daily load.
That's correct.
Phase 3 watershed implementation plan, and so forth. Is that still in the bill?
That is. Mm-hmm.
And so what is a climate load allocation? What is that?
So as the bill, the purpose of the bill was that the MDE does not have appropriate precipitation data, and they've been using precipitation data from 30 years ago, which would be incorrect. So as they're adding the new precipitation data at least every 5 years, other reports then have to be updated.
So climate load allocation means rain?
I'm sorry, Delegate, say that again.
So climate load allocation, and this is a sincere question because it's a term I've never seen before in a bill. Does that mean rain? How much it rains?
It accounts for the climate change as it relates to the WIP.
So what does that
And
mean?
the state is already doing it.
And this is important because I don't know, you use the term climate change, and that is a kind of a catch-all phrase. It means about 1,000 different things to 1,000 different people.
Madam
So
Speaker.
I'll go back to the original intent. The original intent is that we were using data from 30 years ago. I mean, if you remember 30 years ago, I was 14 and it didn't rain. It didn't rain. The weather was not the same 30 years ago as it is now. And rain events were not the same 30 years ago as they are now. And so as we've updated this information, other reports as it relates to our TDML and WIP have to be changed.
I thought it rained a lot 30 years ago too in Maryland, but so climate load allocation in terms of the bill is defined as, and if the chairman wants to answer, because these are sincere questions, does it mean, that means rain, how much it rains?
That is correct, precipitation data, and water runoff, so on and so forth.
Got it, thank you.
You're quite welcome.
Gentleman from Talbot.
Thank you, Madam Speaker. Quick question. Does this apply to Baltimore cities under consent decree? How does this apply to Baltimore City?
So one, I would like to first say that the cross file is on the governor's desk, ready to be filed, and it is the same bill as this. I think we had this discussion about Baltimore City. It affects everybody.
So the reporting also applies to Baltimore City?
Yes.
Okay,
Delegate.
thank you.
Is there any further debate? Gentlelady from Carroll.
Thank you. You said the cross file's on the governor's desk.
The cross file is passed. That's
So one bill has already passed both houses, so this
H-
doesn't really matter.
I'm sorry, say
The
that again,
House
Delegate.
bill is on the governor's desk.
Okay.
for signature.
Question on this bill. It says here that they're concerned about the timeframes. Did that get changed in the amendments, the timeframes?
Yes, that's the Senate amendment.
And what about the retroactive changes? Or is there ability to go retroactive on some of these things when the report comes out?
I don't think I understand the question.
One group was concerned about the ability to go retroactive on some of these.
Yeah, and there's no
issues.
retroactive. It's just moving forward. The department needs to add precipitation data.
And then the department had an issue that they didn't have access to the appropriate kind of data. Has that been resolved as well with the department?
Yes, it's going to be, if I remember correctly, the assistance of some other organizations and nonprofits to help provide that information to
So
them.
are they now supportive of the bill?
Yes.
And also the, what was this? Association of Commercial Real Estate, Maryland chapters, are they okay with the bill as amended?
I'm sorry, was it, who was?
Maryland Association of Commercial Real Estate.
We don't have them having a position, delegate.
Well, it's in the system. They're in opposition. At least
they were
in opposition.
Well, they have not updated if they.
And some of their reasonings, and it might have been addressed in the amendments. I don't know. But they were talking about how we keep updating these plans, and they already have existing buildings, and then they affect the existing commercial buildings, and that's problematic. On mitigating something that's already passed under
That's true.
plan.
That's understandable, delegate. But the weather changes, and so we've been using 30-year-old weather data, and now we need to be using more accurate data, and so that's why those changes.
I'm not disagreeing. I'm disagreeing with the possibility of retroactivity for buildings that are already built. That's
So they actually wanted a stakeholder in the bill, and we actually have a stakeholder now in the bill, so now they are satisfied.
well. Let's hope that's true. Thank you.
You're welcome.
Is there any further debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 95 votes in the affirmative, Senate Bill 227, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 250, Criminal Law, Sexual Crimes, Fourth Degree Sexual Offense, and Spousal Defense.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 114 votes in the affirmative, Senate Bill 250, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 359, Department of Transportation Urban Tree Program Establishment.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 116 votes in the affirmative, Senate Bill 359, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 483, Solid Waste Management, Organics, Recycling, and Waste Diversion, Food Residuals.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, clerk will take the call. There being 95 votes in the affirmative, Senate Bill 483, having received a constitutional majority, is declared passed. Calendar of third reading, Senate Bills number 38. Clerk will read the first bill.
Senate Bill 314, Board of Revenue Estimates and Bureau of Revenue Estimates, Organization and Operations.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, clerk will take the call. There being 108 votes in the affirmative, Senate Bill 314, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 365, Neighborhood Business Development Program, Food Desert Projects, Business Retention.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 135 votes in the affirmative, Senate Bill 365, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 591, Bureau of Revenue Estimates, Tax Incidence Study, Scope and Intergovernmental Assistance.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 135 votes in the affirmative, Senate Bill 591, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 596, Election Law, Early Voting Centers, Hours of Operation.
Is on third reading and final passage. Is there any debate?
Madam Speaker?
Recognizing the gentlelady from Howard.
Is the floor leader rise for a question?
Floor leader?
Oh, Madam Speaker, thank you. Hello.
Hi. This is a question I've been wanting to ask on a number of these bills. Essentially, it's why? Do we have people who come to us and say that they have not been able to vote?
Well, the reason for this legislation, which we also passed the House bill, is that there are people who at the current hours are not able to vote during early voting because our hours are, as you know, currently start at 10 a.m. But there are people who work odd hours, and we want to expand as much as possible. And Delegate, I think that this also standardizes voting hours in terms of election day and early voting. It's a bit confusing to voters at times when we have different hours for early voting and a different set of hours for election day. So the process, this bill also just creates a smoother process so that when we're talking to our voters, it can be clear that the times are the same for every day that they're able to vote.
Well, thank you. We're spending more and more money, and it sounds good because we don't want to keep anybody from voting. But with absentee ballot and mail voting and early voting and weekend voting, I cannot believe there is one single human being in this entire state who literally cannot get to vote. And I'm not sure why we continue to spend more money to do something that is essentially for, I hate to say for show, but it's not actually accomplishing anything that we need to accomplish. There's so many things we do need to accomplish in this legislature for so many people. I just have a problem spending money on something like this. So, thank you.
Is there any further debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 119 votes in the affirmative, Senate Bill 596, having received the constitutional majority, is declared passed. Yea and nay, consent calendar 8, House bills passed in the Senate. The clerk will read the first bill.
House 09, Delegate Chetty.
Recognizing the majority leader.
Thank you, Madam Speaker. I move that the reading of House Bill 9 be considered the reading of all the bills on the calendar.
So ordered. Could the chairmen please come forward? If everyone could please take their seats. We are not coming back this evening. We are coming back in the morning at 11 a.m. You can probably expect 2 sessions tomorrow and probably the rest of the week. We're going to call on the Republican caucus chair, then we'll do and then the committee chairs. Republican caucus chair.
Thank you, Madam Speaker. Fellow members of the Republican caucus will be meeting at 10 a.m. tomorrow morning. Please pay attention to your email. The link will be sent tomorrow morning at 10 a.m.
Democratic caucus.
Thank you, Madam Speaker. Colleagues, we were possibly having a Democratic caucus meeting tomorrow at 10. I'll send you guys a message before close of business today. Thank you.
Okay. The Judiciary.
Thank you, Madam Speaker, members of the House. The House Judiciary Committee, I'd like the subcommittee chairs. We're going to have a meeting with the subcommittee chairs at 4 o'clock. We're going to have a voting session at 5 p.m. this evening, 5 p.m.
Health and Government Operations.
Thank you, Madam Speaker. That committee will have a voting session at 4 p.m. and there will be a chairman's meeting prior to that.
Environment and Transportation.
Thank you, Madam Speaker. The Environment and Transportation Committee will have a voting session at 3:30. And just to remind folks, the motor vehicles and the natural resources subcommittees will be meeting prior to that.
Ways and Means.
Thank you, Madam Speaker. That committee will move back its voting session until 4 p.m. today. And for those on the Revenues Subcommittee, your voting session is at 2:15. 2:15.
Economic Matters.
Thank you, Madam Speaker. The Economic Matters Committee will not meet today.
Appropriations.
Thank you, Madam Speaker. The Appropriations Committee will meet at 2:45 for a voting session.
Okay. All right, I think that's it. That ends work at the desk. Quorum call before adjournment.
Madam Speaker.
Has everyone recorded their presence? The clerk will take the call. There being 134 members present, the House is still in session, recognizing the majority leader.
Thank you, Madam Speaker. I move that the House stand adjourned until Wednesday, April 7th at 11 a.m., Legislative Day, March 22nd.